Good morning, everyone. It is 9 o'clock, and welcome back to the California WaterFix Water Right Petition hearing. I am Tam Dodek, board member and hearing officer. Joining us shortly will be board chair and co-hearing officer Felicia Marcus. And then a little bit later, we'll also be joined by board member Dee Adamo. To my left are Senior Staff Counsel Dana Heinrich and Senior Water Resources Control Engineer Kyle Oceandesco. We'll be also be joining by Environmental Program Manager Diane Riddle. Some general announcement. Oh, we also have Ms. McHugh and other staff here today to provide assistance as well. Some standard general announcement before we begin. Please take a moment right now and identify the exits closest to you. We are in a different room today. In the event that an alarm sounds, we will evacuate this room. You'll either be directed into a protective vestibule or take the stairs down to the first floor, exit, and we will convene in the park awaiting the all clear instructions to return. Secondly, this hearing is being recorded and being webcasted. So please always speak into the microphone and always begin by identifying yourself and whom you represent. We have a court reporter with us today. Thank you and welcome back. The transcript will be available after the completion of Part 1A. If you need to have it earlier, please make arrangements with the court reporting service. Finally, and most importantly, as you know by now, please take a moment and put all your noise-making devices on silent, vibrate, off, whatever that does not create a noise. Even if you think it's already so, please take a moment and check, as I am doing now. All right. Before we resume any housekeeping procedural matter, I will note that Mr. O'Loughlin notified me early today that he and the state water contractor will be switching places in the order of cross-examination of this panel because he will not be available later. Are there any other issues, Mr. Mizell?
That's your fault, too.
It's too early to start into this with Mr. O'Loughlin. Mr. Mizell.
Yes, earlier the hearing officers indicated a desire to bring back all of the witnesses for further questioning for the board's purposes on September 29th and 30th. In a response, I indicated that there are key modeling staff who are consultants to the department who have conflicts with the 29th, but will be available on the 30th. And if it makes sense, if we could agree to schedule the modelers for the 30th, that would help with my logistical needs.
We will so schedule the modelers for the 30th. Anything else? All right, with that, Mr. Mizell, are you ready with your water rights panel?
Yes, we're ready. So the panel you have before you today are Ms. Maureen Sargent, Mr. Rob Cook, and Mr. Ray Sahlberg. They'll be discussing water rights and presenting a PowerPoint presentation on the matter to summarize their written testimony.
And at this time, I'll ask you to please stand and raise your right hands. Do you swear or affirm that the testimony you are about to give is the truth? If so, answer yes, I do.
Yes, I do.
Thank you very much. You may begin, Mr. Mizell.
Thank you. Ms. Sargent, is DWR Exhibit 19 a correct copy of your statement of qualifications?
Yes, it is.
And is DWR Exhibit 53 a correct copy of your written testimony?
Yes, it is.
And Mr. Cook, is DWR Exhibit 20 a correct copy of your statement of qualifications?
Yes, it is.
And is DWR 60 a correct copy of your written testimony?
Yes, it is.
And I'll turn the mic over to Amy Oftenberg.
Hello, Amy Oftenberg for the Department of Interior. I have a couple of issues with Mr. Sahlberg that we'd just like to address at this time as well, just to clarify some things. But first we'll start with, Mr. Sahlberg, is DOI 1 a true and correct copy of your statement of qualifications?
Yes, it is.
Is DOI 1 for a true and correct copy of your written testimony.
Yes, it is.
And we have a couple of things at this point. Well, I guess just to be clear on the record, we wanted to go through and have Mr. Sahlberg verify DOI 5, DOI 5 errata, DOI 9 through 31 consecutively. Are those all true and correct copies?
Yes, they are.
Thank you. Then we have a portion of Mr. Sahlberg's testimony, especially in the PowerPoint, that is a background section for the CVP project description. It's a project description of the CVP, not of the Cal WaterFix. We offer it as factual testimony just to make sure that some of the basic infrastructure facts of the CVP are in the record. So we could forego, we could submit that and he can be cross-examined on it, but we don't believe he needs to actually present it orally unless you would like to see it.
I'm sorry, help me understand. You presented it as background information. The expert, in your opinion, is qualified to testify and answer cross-examination on it, but...
Yeah, but this portion of the CVP facilities is really just factual testimony for the record. We're more than happy to go through it, and either way, is obviously eligible to be cross-examined on it. But in the interest of time, we think that most people in this room probably have a pretty good understanding of the facts in here. So we could just...
No, you do not need to cover it in your direct, if that's the question.
Yeah, that's the question.
Okay.
Okay, thank you. And then we have one more. If we're ready to, if it's possible to bring up Mr. Sahlberg's written testimony, which is DOI 4. If you could go to page 2 of that. And down to the second paragraph that starts right there, we can see that. Mr. Sahlberg, do you see the second paragraph on page 2 of your written testimony, DOI 4?
Yes, I do.
Do you have any clarifying statements you'd like to make about that paragraph?
Yes, the first sentence says that I join in the testimony of Marine Surgeon of the Department of Water Resources. What I meant by joining the testimony is that I agree with her analysis and conclusions and saw no need to repeat the same analysis in my written testimony.
Thank you. That's all we have. Thanks.
All right, thank you.
With that, we'll turn to Ms. Sargent, who will present a oral summary of her written testimony, and she may provide 2 clarifications or corrections to details in her written testimony, which we will then follow with a written errata sheet that we will submit and serve on all parties.
Yes, before I begin with my direct, I just wanted to make 2 corrections in my testimony, to typographical errors. The first one is on page 8 of my testimony at line 19. It currently says, or decreased by 1.2 million acre feet. It should read decreased by 1.1 million acre feet. And then the second correction is on page 20 at line 2. It reads currently DWR-303. It should read DWR-304.
Thank you. So noted for the record.
With that, good morning, Chair Dudek, Board Member Marcus, and Board staff. I am Maureen Sargent. I'm a senior engineer with the Department of Water Resources. I work in the State Water Project Analysis Office, and for the past 24 years, my responsibilities have included primarily working with State Water Project, water rights, and water transfer related activities. As part of my testimony, I will summarize the 4 State Water Project water rights that are involved in the California WaterFix petition for change. I will address the issue raised by the board as to whether or not the petition would in effect initiate a new water right. I will then briefly examine some of the information provided in earlier panels and describe how DWR believes that the information provided by DWR and Reclamation is sufficient for the board to make its necessary finding that the petition can be approved without injuring other legal users of water. Lastly, I will describe several different categories of contracts that DWR has executed with its State Water Project contractors as well as diverters upstream on the Feather River and within the Delta. DWR holds 4 water rights permits that provide the primary water supply for the State Water Project. DWR diverts water under those water rights to 29 State Water Project contractors, primarily for municipal, industrial, and irrigation purposes. Those contractors are located in the Feather River, San Francisco Bay Area, San Joaquin Valley, Central Coast, and Southern California area. In addition to the water delivered to our State Water Project contractors, we release significant amounts of storage for salinity control and fisheries purposes. The State Water Project water supply is derived primarily from a combination of unstored water in the Feather River, unregulated flow in the Delta, and upstream storage releases. As you've heard described by a number of other individuals, the State Water Project appropriates water only after it meets all of its regulatory requirements and contractual requirements. And due to the current location of the State Water Project export facilities in the Southern Delta, there are a number of times, even during excess flows, when that location results in a significant constraint on the ability to export water. DWR and Reclamation are jointly responsible for meeting most of the objectives contained in D1641. Water right decision D1641. 1641. And the 2 projects coordinate their operations. As you heard Mr. Lehi testify earlier, the State Water Project is operated consistent with all of our regulatory obligations, including those contained in D1641, the 2 biological opinions for Delta smelt and for salmon, the Corps of Engineers permit, the Department of Fish and Wildlife incidental take permit, and any other obligations that are placed on the State Water Project. Would you prefer I slow down? This is a table that I prepared to summarize the 4 State Water Project water rights that are included in this petition. As you can see, the water rights contain individual quantities for both direct diversion and diversion to storage from the Feather River near Oroville, as well as from the Sacramento-San Joaquin Delta. Those 4 permits currently contain a number of points of, currently authorized points of diversion and rediversion. The 2 permits that authorize diversion from the Feather River include locations in the Oroville Thermalito Complex, as well as the North Bay Aqueduct. And all 4 permits contain authorized points of diversion at Clifton Court Forebay, which is the intake to Banks Pumping Plant, as well as the Jones Pumping Plant, and a location identified as the Delta Water Facilities, which is located near Hood. That location was the originally intended intake to the peripheral canal. The current proposal before you is to add the 3 new points of diversion in the North Delta, identified as California WaterFix intakes 2, 3, and 5. As you saw earlier, all 4 permits contain individual amounts that identify how much water can be diverted or rediverted under each permit. However, all 4 permits contain a term that limits the maximum rate of diversion, combined rate of diversion from the Delta under all 4 permits to 10,350 CFS. You've heard already that the petition before you requests the inclusion of 3 new points of diversion. The 3 intakes have a maximum design capacity of 3,000 CFS each. All of the other provisions contained in the permits will remain unchanged, including the source of water, the rate of direct diversion and diversion to storage, the season of diversion, the maximum combined rate of diversion from the Delta, which will remain at 10,350 CFS, and the place and purpose of use. In its notice of the petition for change, the Water Board identified one of the issues to be addressed as whether or not this petition would in effect initiate a new water right. Water Code Section 1701 identifies that, or specifies that a water right holder can change its point of diversion with the approval of the State Water Board, and consistent with the requirements of Water Code Section 1701 and the reasoning provided by the State Water Board in its decisions. This petition requests no increase in the maximum rates of diversion under any of the permits, no change in the season of diversion, no change in the source of water to be diverted, and no change in the combined maximum rate of diversion from the Delta. Water Code Section 1701 does not restrict the number of diversions that can be requested or the size of any particular diversion if it is within the existing permits of the water rights. Therefore, DWR believes that this petition does not, in effect, initiate a new water right. DWR and Reclamation have developed the information that's being presented in its petition, as well as the information that was provided for this hearing, in order to provide the board with sufficient information to make its required finding that these facilities can be designed and constructed and operated without injuring any other legal user of water. As has been discussed in earlier testimony, DWR and Reclamation operate first to meet in-basin and all regulatory and contractual requirements. All existing protections, including those in D-1641, will remain in place. There will be California WaterFix specific requirements that will be adopted as part of any order, and those must be in effect before any water could be diverted through the facilities. The California WaterFix does not change any of the upstream operational criteria. And DWR will continue to meet the terms and conditions of any of our upstream contractual requirements, as well as in-stream flow requirements. Because the projects are operated first to meet the in-basin demands, the availability of unregulated flow to other legal users will not be diminished. And while there may be small changes during lower flow periods in water levels, we've shown that those changes are small. Those changes are both small in size and duration, as well as the number of years in which those would occur. And while there may be some small changes in water quality, the modeling also shows that D-1641 requirements can continue to be met, and that upstream end of September storage will remain unchanged. DWR has exclusive right to their storage. And while there may be some changes as a result of a change in release schedule or a change in quantity of those storage releases, no other water right holder has a right to those storage releases. And as I mentioned earlier, while the modeling shows there may be some small changes in water quality, the requirements contained in D1641 will be met. And those requirements were established under the Water Board's water quality responsibilities in the Water Quality Control Plan. Most of those objectives were implemented on the projects through D1641. And the department is committed to continuing to meet those objectives to protect those beneficial uses. I'll now describe several different categories of contracts that the department has executed. The first type is the long-term water supply contract that DWR has executed with our water supply contractors. Those contracts identify how we allocate the water available in any particular year to those contractors. We executed water supply settlement agreements with diverters that had existing water rights on the Feather River. The major settlement agreements involved 6 contractors who had prior rights. We also have general settlement agreements with parties in the Delta. Some of those agreements contain a water supply component, some water quality, and some a combination of both. And the settlement agreements were executed during the time when DWR had applied for its initial petitions or to appropriate water, and during the period when facilities were being constructed. They were executed to address issues associated with state water project operations, both on the Feather River and in the Delta. And DWR is committed to continuing to meet the terms and the conditions of both the long-term water supply contracts and all of these settlement agreements. DWR delivers water to 29 state water project contractors, consistent with the terms of the water supply agreements. Those agreements each contain a Table A amount, and that amount is essentially the proportional share of each contractor's proportional share of the water that is determined to be available in any particular year for delivery to the contractors. The current combined maximum Table A for the contractors downstream of Oroville is just under 4.2 million acre-feet. As you heard Mr. Lehi discuss earlier, the water that is determined in any particular year to be available for delivery to our water supply contractors considers first the hydrologic conditions, the upstream contractual requirements, any of our regulatory requirements, including what is necessary to meet Delta objectives, among a number of other concerns. Those contracts contain no specific guarantee of any quantity beyond their share of what's available in any particular year, and they do not contain any entitlement to a particular operational scenario or end-of-season storage in Oroville. And DWR has sole discretion over the operation of its state water project facilities. The primary settlement agreements that DWR holds with diverters on the Feather River include 6 settlement contracts with diverters who had prior rights to divert from the Feather River, both in the location near Oroville. They currently divert now out of the Thermalito Afterbay, as well as 4 contractors that divert downstream of Lake Oroville. Each of those contracts provides for a defined water supply with a specific contract efficiency that is tied solely to the inflow to Oroville. We can cut those contractors only in years when the inflow to Oroville meets or is below specific targets. DWR operates Oroville each year to first consider how much water is necessary to meet those contractual obligations in each of those contracts. However, the contracts themselves do not assign any portion of DWR's water rights to any of those contractors. They do not contain any specific entitlement to storage in Oroville or entitlement to any particular operational scenario or end-of-season target storage. DWR retains sole discretion over Lake Oroville operations. The California WaterFix does not change any of the upstream operational criteria. It doesn't change any of the terms of these settlement agreements. And as DWR has done historically, we will continue to meet the Feather River in-stream flow requirements as well as the obligations under those settlement agreements. DWR has settlement agreements with 5 different entities in the Delta: Contra Costa, City of Antioch, North Delta Water Agency, Byron Bethany Irrigation District, and East Contra Costa Irrigation District. The Contra Costa Water District and City of Antioch contract both specify the number of days that water of a particular quality shall be available at their point of diversion. And they also identify what will be considered the water supply deficiency if those number of days are not met, and what the compensation for that water supply deficiency will be. The department executed an agreement with North Delta Water Agency in 1981, and that agreement is for water of a suitable quality for diversion by any of the diverters within the boundaries of the North Delta Water Agency. The North Delta Water Agency contract includes essentially the entire North Delta region, and so it covers all of the diverters within the North Delta area. That contract specifies the water quality to be obtained at a number of different locations throughout North Delta Water Agency. And it also identifies, it contains drought emergency provisions that identify what controls during a drought and what steps the department should take, as well as provisions to compensate landowners if in drought emergencies the department is unable to maintain those water quality objectives. The Byron Bethany Irrigation District is an agreement that addresses issues as between BBID and the department for its diversions from the intake channel to the Banks pumping plant. And the last contract, East Contra Costa Irrigation District, DWR executed an agreement with East Contra Costa in 1981. And that agreement recognized but did not quantify East Contra Costa's pre-1914 water right. And it contains water quality objectives that must be maintained at Indian Slough. And those objectives are intended to protect the historic agricultural use within East Contra Costa from April through October. Subsequent to signing the agreement, East Contra Costa and Contra Costa Water District requested an amendment to that agreement to allow water under the East Contra Costa agreement to be diverted at Contra Costa's diversion facilities at Rock Slough and Old River for municipal treatment and delivery to the service area of East Contra Costa. There was some change in use within the district, but East Contra Costa has no ability to treat for municipal purposes. It is an ag district. Although this represented a change in purpose of use as well as season of use from the historic use within East Contra Costa, DWR agreed to allow the change on the condition that it did not result in a greater water supply demand on the project, as well as a recognition that the water quality objectives for agricultural purposes contained in the agreement would be the controlling objectives required. And if in drought emergencies, DWR was not able to maintain those, and there were diverters within the district that saw crop losses associated with that, any impacts associated with water quality would be limited to agricultural diverters within the district. These agreements were executed to address potential issues associated with state water project operations within the Delta. And those agreements contain provisions whereby the districts consent to the diversions by the projects from the Delta as long as those agreements are in effect and the department is in conformance with those agreements. Again, the California WaterFix will not change any of the terms of these agreements, and we will continue to honor the commitments in those agreements. In March of this year, DWR executed a settlement agreement with Contra Costa Water District related to potential CEQA effects associated with the California WaterFix. This agreement allows Contra Costa water to be diverted, a portion of Contra Costa's water to be diverted through the California WaterFix facilities. The amount of diversion depends on or varies from 2 to 50,000 acre feet a year, depending on the amount of water the total amount of water that is diverted through those facilities. The source of the water is Contra Costa water. There is no water supply component of the settlement agreement. It does not increase total annual diversions from the Delta, nor does it increase the diversions by Contra Costa. And based on the analysis done by Dr. Nader Tehrani, it does not affect other legal users in the Delta. So in conclusion, DWR believes that it has demonstrated that the California WaterFix facilities can continue to operate within all the terms of the existing permits and the existing regulatory requirements protecting other legal users. There will be no expansion of the quantity, rate, timing, source, purpose, or place of use of any of the under any of the water rights. It will not, in effect, initiate a new water right. And we believe that this information supports the finding by the board that the California WaterFix petition can be approved without injuring other legal users as a result of the construction or operation of the state water project.
Thank you, Ms. Sargent. Before you continue, Mr. Mizell, let me just note for the record that during the presentation of Ms. Sargent's testimony, we've been joined by Chair Marcus, Board Member Diadamo, and Ms. Riddle. Mr. Mizell.
So that concludes Ms. Sargent's PowerPoint. We will turn it over to Ray Sahlberg at this point. If Ray's slides are not included on this PowerPoint presentation, we have a second file. And
could you identify this Marine Sergeant's PowerPoint for the record? I think it's DWR3.
That's correct.
we may need 5 minutes to get Ray's PowerPoint file to the clerk.
All right, let's take a 5-minute break. We'll resume at 9:40. Okay, please take your seats. It's 9:40. We are back on record. Mr. Mizell or Ms. Offenberg, are you ready to present Mr. Sahlberg?
Yes, we are.
Good morning, Hearing Officer Dodak, Hearing Officer Marcus, Board Member Diadamo, Board staff. My name is Ray Sahlberg. I am the Water Rights Officer for the Mid-Pacific region of the Bureau of Reclamation. I lead a group that administers and protects the water rights for reclamation facilities within the region. We review petitions and applications from other parties for potential injuries to reclamation's water rights. We also prepare and file petitions to implement various reclamation projects as required. We are also the group that does the permittee reporting for the Bureau's permits to the State Board. Today I'm here to testify about the WaterFix and its relationship with the Central Valley Project. We are joining the WaterFix petition to add the 3 new points of diversion to certain reclamation water rights. I was going to reclamation, as I stated earlier, we join in and concur in the testimony of Marine Surgeon of DWR on the changes requested by the petition, the fact that it does not initiate a new water right, and the fact that the information provided by the panel, various panels, supports a conclusion by the State Board that the WaterFix will not injure any legal users of water. So, give me a moment. I need to skip through a few things. All right.
And for the record, Mr. Sahlberg, please identify this exhibit.
This exhibit is DOI 5A.
And what page are we on, since it's not numbered?
Oh, my apologies. 2, 3. Oh, I'm sorry, we're on. Can you give us a moment since we're.
Well, we're on the page that's titled CVP Water Rights Permits.
Right, and that would be.
I guess that's the only way to identify it.
This would be starting page 9. That's page 9. That's page 10. Okay. The CVP has 31 water right permits, 22 direct diversion and storage permits, and 9 power permits. 11 permits are the subject, are included in the WaterFix petition. And they are permits for our Shasta, Trinity, and Folsom facilities. The rates of diversion and storage for storage amounts for each permit, for each facility are shown above. There is a a summary of each permit that's part of the petition. Again, we are joining and concurring with DWR's testimony on what the petition is asking for. All other provisions of our permits will remain unchanged. The sources of water, the rates of direct diversion, diversion to storage, the season of diversion, the CVP maximum combined rate of diversion from the delta, which is 4,600 CFS, our consolidated place of use, and the purposes of use under these permits. The existing main points of diversion and rediversion under these permits include Shasta Dam, Trinity Dam, Whiskeytown Dam, Folsom Dam, the Tehama-Colusa Canal, the diversion facilities for our Sacramento River settlement contractors, the Jones pumping plant at Tracy, and Friant Dam. We are proposing to add the 3 new intake locations in the northern delta near Hood to the permits listed in the petition. Here is a map of where all those facilities are. You'll notice the Tracy pump, the intakes between Tracy and Sacramento. Again, we are joining and concurring in Ms. Surgeon's testimony that this is not a new water right. We are not seeking any increase in rates of diversion in the delta beyond currently permitted rates. We are not seeking an expansion in our season of diversion or in the CVP's consolidated place of use. We are not seeking any changes in our purposes of use under our permits. We also join and concur with Ms. Surgeon's testimony that the information provided supports a conclusion that the WaterFix will not injure other legal users of water. It will be operated in a manner that allows reclamation to meet its senior water right obligations and current CVP regulatory and legal obligations. We will continue to honor all senior water rights. Our compliance with D1641 will ensure that there are no impacts to in-delta water users by the WaterFix. Minor changes in water quality will still be within D1641 limits and objectives. And the settlement agreement between the Department of Water Resources and Contra Costa will not affect our ability to meet senior water rights and our legal obligations. I'm sorry. Okay, I'd like to move on to our contracts. Reclamation has several different types of contracts for the CVP. The first one is what we call our long-term water service and repayment contracts. These are contracts for water appropriated under the CVP's water rights. Second type of contract is what we call our water right settlement contracts. These are contracts that settle disputes, water right disputes resulting from the construction of CVP facilities. The contract amount for the water right settlement contracts is negotiated between the reclamation and the contractor. It is not a quantification of the contractor's underlying right. We have 127 long-term water service and repayment contracts. The maximum amount of water deliverable under those contracts is 6.1 million acre feet. The actual quantity for any contractor is any year is dependent on a number of factors, and Mr. Milligan's testimony went into that in detail, and nothing in the contracts governs overall CVP operations. The Sacramento River settlement contracts there's 136 contracts with water users downstream of Shasta Dam. Again, they settled water rights disputes resulting from the construction of Shasta Dam. They do contain a shortage provision that is based on the inflow into Lake Shasta. This is known as the Shasta criteria. Shortage provision provides they get either 100% of their contract supply or 75% of their contract supply, depending on Lake Shasta's hydrology. And the amounts that they receive under the contract are shown above. I would also add the contracts have two components: base supply, which is the quantity to settle the water rights dispute, and project water, which is water appropriated under the CVP's permits, that is provided to cure what we call deficiencies in their water rights. This is delivered typically in the late summer when their base supply or their own water rights would have insufficient supplies to meet their demand. And the amounts that they receive in normal and Shasta critical years are shown there. Other CVP settlement agreements. There's the exchange contract. That's with 4 contractors on the San Joaquin River, which allows us to operate the Friant Division. They exchange their right to divert from the San Joaquin River in exchange for a supply of water from the Delta. That contract has shortage provisions based on the Shasta criteria. And normally they get 840,000 acre feet. In a Shasta critical year, they will receive 650,000 acre feet. We also have 9 other settlement contracts on the San Joaquin River. Those shortage provisions, again, are based on the Shasta criteria. We have these San Joaquin River holding contracts. These are contracts with diverters below Friant Dam to settle a water rights dispute that was the subject of Dugan v. Rank. They provide for 5 CFS at the contractor's point of diversion. And there's no shortage provision in those contracts. And we have 5 other contracts agreements on the American and Stanislaus Rivers to settle other water rights disputes. California WaterFix will not change any provision of these contracts. It will not alter upstream operational criteria. We will not change the terms of the water service, repayment, settlement contracts, or any other operational agreements. We will continue to comply with the terms and conditions of all of these contracts. That concludes my testimony.
Thank you. Anything else? Ms. Mizell, Ms. Offenberg?
No, at this time, the panel is available for cross-examination.
All right. Before we proceed, a question for the court reporter. I've seen you turn your head to try to look at the screen. Is it helpful for you? If so, could we ask that during the break, perhaps a monitor be set up for her so that she doesn't have to keep turning back and forth? Would that be helpful? Yeah, we'll try to make that happen. All right, thank you. With that, we will now turn to cross-examination, and Mr. O'Loughlin, you are up. Mr. O'Loughlin, I don't see Ms. Morris in the room. Is that because, or is the state water contractor represented here today? Okay, if that's the case, then Mr. O'Loughlin, I will still allow you to go first because of your scheduling conflict, but I would prefer then to go back to the order, and we'll start with the state water contractors after you. I'm glad you add that caveat of today, because, you know.
Well, yeah, it should be.
Okay. Don't worry, I'll get it. Is that better? We have the exhibits that we used last time. There's a list of them. We met your statements of telling you what they were. We'll call them up during the cross-examination. You wanted to know ahead of time what we would be discussing. So there's two areas of inquiry. One with Mr. Sahlberg has to do almost exclusively with the operations of New Maloney's Reservoir and meeting requirements at Vernalis and or the interior delta. We have some minor questions about the permits for that Reclamation has put in for the WaterFix projects and what's in and out. We also have some questions about the permits and their ability to divert San Joaquin River water at Jones. So we're pretty much focused with Mr. Sahlberg on the south end of the valley. In regards to Ms. Sargent's testimony, we will be inquiring about the scope and extent of what DWR did to ascertain the changes in reservoir storage at the projects under California WaterFix on a monthly basis, and how those did or did not match up with senior water right diverters in the Sacramento San Joaquin Bay Delta. So those are the two general areas of inquiry.
On that second one, well, I guess I'll allow you to continue
No, go
before
ahead.
I
You can
ask.
ask.
But to the extent that Ms. Sargent cannot get into the modeling or any of the technical aspects, you might not get the answer you're seeking.
Oh, I fully expect not to get the answer I'm seeking.
Mr. O'Loughlin,
I hate giving away the story at the beginning, but yes, an exercise in futility here today. But yes, we have to make a record, and we'll just go through the process, and I'll ask the questions, and I'm sure there's a lot of questions that will not be answered, but that's perfectly
right.
okay.
Mr. O'Loughlin?
So it's probably going to take at least an hour, but probably not much more, I hope. Okay. Ms. Sargent, my name's Tim O'Loughlin. I represent the San Joaquin Tributaries Authorities and the member units. On page 11 of your testimony, line 6, you state that the, starting at line 4 really, the SWP and CVP must continue making supplemental storage releases to meet the D1641 requirements, even after they have ceased appropriating unregulated flow. Is that a true and correct statement in regards to the operations of New Maloney's Reservoir? New Maloney's Reservoir.
Excuse me, can you, as far as whether we have ceased?
No, whether you continue to make releases to meet D1641 even after you have ceased appropriating unregulated flow at New Maloney's Reservoir.
With respect to operations at New Melones Reservoir, you're going to have to ask, it's as far as the schedule of releases. But with respect to Term 91 conditions.
No, this is not Term 91. Read the statement. It says D1641. So my question is...
Hold on, Mr. O'Loughlin. It would be
Yes.
helpful if we could get that portion up so that all of us can see what Mr. O'Loughlin is reading.
Sure, that's Maureen Sargent's direct testimony, page 11, starting at line 4.
So DWR 19.
Yes.
Oh, no, I'm sorry, statement qualification, written testimony.
DWR
is
53.
53, yep. And page?
Page 11. Page 11.
Lines 4 through 7.
Yes, this statement is correct in that if the requirements are not being met in the Delta and we are no longer making appropriations of unregulated flow, DWR and Reclamation must make supplemental storage releases. The operators determine where those supplemental storage releases must come from, depending on
But my
what they are
question
trying
was-
to meet.
So I knew this. Okay, look at, you got to focus on the question. The question is very specific. It's to New Maloney's Reservoir, okay? If you can answer the question in regards to New Maloney's operations, answer the question. If you prefer that you don't know the answer, just say you don't know.
Mr. O'Loughlin, enough. State the question.
Well, the question, I'll just have it read back. Can you please read it back?
I think it's more efficient if you re-ask the question.
Okay. So looking at this line again, do you know if New Maloney's Reservoir continues to release water from supplemental storage releases to meet D1641 requirements at Vernalis after they have ceased appropriating unregulated flow?
To my knowledge, they do. You can
Okay.
confirm that with Mr. Milligan.
Did you confirm that with Mr. Milligan?
I did not ask Mr. Milligan.
Okay. What evidence have you relied upon that that Reclamation continues to release water from storage to meet D1641 requirements at Vernalis?
My knowledge with respect to New Melones operations is limited to my conversations with Reclamation, so I'll defer any further questions on it to
Well, no,
Ray.
that's fine, but that's not going to happen. So, because you said you believe they did this, and you said you confirmed it. So, who did you talk to at Reclamation that told you that Reclamation continues to release water from storage to meet requirements of D1641 at Vernalis?
It's based on my conversations with water rights staff at Reclamation and
Who would that be?
CVO staff. That would be both Ray Solberg and Lisa Holm, as well as Liz Kiddick.
And they told you that Reclamation meets the Vernalis requirements under D1641?
As required and as they can.
So as you sit here today, then you believe that the statement set forth on page 11, lines 4 through 7 that we just went through is true and correct. Is that true?
I believe it is.
Mr. Solberg, I have some background questions for you first. You graduated from Santa Clara University School of Law in 1993, is that correct?
Yes,
When did you take the California bar at that time?
I took it in that summer, yes.
Okay, did you pass?
Yes, I did.
And so you've been a member of the California bar since 1993?
Objection relevance.
Well, it goes
Mr. O'Loughlin?
goes to his expertise, his background, his ability to testify, goes to the weight of the testimony.
Go
We're
ahead,
not-
Mr. Solberg.
Yes, I've been a member of the bar since then.
Now, since looking at your resume that you attached, it doesn't appear that between 1993 and 2003 that you did any work regarding water rights. Is that correct?
I did some work related to my job as a repayment specialist with the Bureau starting in 2000.
And does a repayment specialist expertise have to do with water rights?
They have to have some knowledge of water rights in working with the contracts.
Okay. And then since 2003, you've been dealing with water rights for the United States Department of Interior and forward, correct? Water rights?
Actually, I started the position as water rights officer in July of 2006. During the time I was in Washington, I did a lot of things related to reclamation, not just water rights.
In regards to your work from 2003 to 2006 for the United States Department of Interior, can you tell me kind of generally how much of your work was done in regards to California water rights as opposed to other water rights in the western states?
Almost none.
And would it be safe to say that since you've taken on the responsibility as the water rights officer for the Mid-Pacific region from 2006 to the present, almost all of your work has been with California water rights, is that correct?
That's correct.
I noticed in your PowerPoint that it's Reclamation's, your testimony that 3 new points of diversion are going to be requested for 11 permits identified in your PowerPoint. Is that correct?
That's correct.
Okay. I noticed in the 11 permits identified for the PowerPoint that there are no permits for the new Maloney's project.
That's true.
Why are there no permits for the new Maloney's projects that were submitted as part of the California WaterFix?
One reason is currently the place of use for New Melones is limited to 4 counties. And the WaterFix would be delivering water outside of those counties. That is probably the main reason.
Is it your understanding that there are going to be appropriate delta flow criteria as part of the proceedings for the California WaterFix?
My understanding.
Okay. Do you have any understanding as you sit here today whether or not the flows that have been presented at Vernalis include the Bureau's position regarding appropriate delta flow criteria? In other words, you've said that you're going to try to meet D1641, you're making salinity releases, you're meeting other obligations. Do you consider the modeling that you presented to be the appropriate delta flow criteria for Vernalis?
Objection, asked and answered. We went over this with the modeling.
No, this isn't a modeling question. This is a water right question. Because this is going to go to the question of whether or not how the permits at New Melones operate and are subjected to or not subjected to the California WaterFix. And I'll just tell you, I'll just...
Actually,
No.
that's fine. I'm going to ask him to answer.
I'd like to at this point reiterate the department's standing objection to discussions regarding the San Joaquin River, as those are not a part of the California WaterFix.
Well,
So noted. Go ahead and answer, Mrs. Sahlberg, to the best of your ability.
I'm sorry, can you repeat the question, please?
Well, can I, no, wait, can we just take just 1 second, if I may, Chair? That's an important point, and I don't know what we want to do with it right now, but if truly DWR and Reclamation's position is that the San Joaquin River is not going to be involved at all in California WaterFix, including the appropriate delta flow criteria, I'm happy to stop my cross-examination, drop my protest, and leave. Because that's an important point, because and I'll just tell you where I'm going with this so you have a sense of what I'm trying to do here. We've always had the position that we're not opposed to WaterFix, and we're not proponents of WaterFix. We just don't understand WaterFix. But our concern is that more water would be coming out of the San Joaquin River to meet the California WaterFix permit terms and conditions, including appropriate delta flow criteria. If they're saying that the San Joaquin River is off the table in regards to the California WaterFix permit terms and conditions, we're perfectly happy with that. I don't know if you're happy with that. Okay, I'm just being honest about it. I don't know if that's included or not, but we'll be out, and I'll stop. That's my concern. I mean, I can go through all these questions, and I take Mr. Mizell, you know, if we're out, we're out, and I'll stop. And it poses an interesting question, and if you want to take a break and talk to your counsel, you could, because our concern you get it? Okay.
I got it, Mr. O'Loughlin, and I'm not prepared to let you off the hook that easily. Let's go ahead. You know, whatever agreements you want to discuss with Mizell and the petitioners, you do that on your own time. Let's go ahead and just proceed. Unless Mr. Mizell would like to stipulate without binding the board, let's go ahead and allow Mr. O'Loughlin to proceed with his questioning. And now we have totally confused Mr. Sahlberg.
Well, no, I'm waiting to hear from DWR. I mean, because quite honestly, trust me, currently at this time, as you well know,
Mr. O'Loughlin,
my clients have
Mr. O'Loughlin, Mr. O'Loughlin, enough. You've asked a question. Mr. Mizell, do you still have an objection?
I do still have the standing objection that the San Joaquin system is not part of the California WaterFix project. I'll be clear, though, it's not the department's position that it is incumbent upon us to dictate what the appropriate delta flow criteria are. We read the Delta Reform Act to mean that the board has the purview and the responsibility under that act to consider what they believe are the appropriate delta flow criteria, and we will meet the regulatory requirements imposed upon the department. So I'm not in that statement letting Mr. O'Flaughlin off the hook, because I do not know what is within the board's mind as to what they want to consider on appropriate delta flow criteria. The project as proposed, however, does not include any changes to the San Joaquin system at this time, because we are not putting forth what we believe is the board's duty to determine those appropriate delta flow criteria.
All right, that's enough
Sure.
testifying from both councils. Mr. Selberg?
If you are asking me whether the modeling for the WaterFix includes a component of alpha from the San Joaquin River, I would say you would have to ask the modelers.
And that would have been Kristen White, correct?
Among others.
And is that outflow component fully set forth in the documents that Reclamation presented as part of the California, part of this proceeding?
I'm sorry?
Yeah, is the Vernalis outflow component presented as part of the petition in the testimony here today?
No, I don't think so. I don't really understand the question.
Okay, so let's continue on. You said earlier that the New Melones permits are regulated to the 4 counties. Can you explain to the board what you meant by that?
The New Melones permits limit the delivery of water appropriated at New Melones under the Bureau's permits to 4 counties, which are Calaveras, San Joaquin, I think Tuolumne, and I can't remember the other one off the top of my head.
Were you present when Mr. Milligan testified here at the WaterFix?
I was in the audience.
Okay. Were you present when Ms. Kristen White testified here at the California WaterFix proceedings?
I was in the audience.
Okay. Is there any portion of the testimony that either Mr. Milligan or Ms. White presented that you disagree with?
No.
If you could turn your attention to page 2 of your testimony, Mr. Sahlberg.
Okay.
Unfortunately, your testimony does not have lines, so we'll have to figure out what we're talking about. But it looks like it's 1, 2, 3, 4. Looks like it starts on line 6.
Let's, for the record, identify it as DOI 4. Is that correct?
Sure.
Yes.
Yes. Starts with in managing the delivery of CVP water.
Okay.
Okay. So I'm going to focus once again, and this is on New Melones.
Okay.
Do you consider it says that Reclamation operates its facilities to meet all statutory and regulatory requirements prior to satisfying contractual obligations? See that line?
Yes.
Okay. So when you talk about contractual obligations in regards to this statement at this location, is this how the priority occurs at New Melones Reservoir in regards to the 88 agreement between Oakdale and South San Joaquin irrigation districts and the United States Bureau of Reclamation?
We consider meeting senior water rights to be a statutory and regulatory obligation.
So then if I understand that correctly and maybe rephrase it a little bit differently, then it would be your testimony that the 1988 agreement would be a statutory or regulatory requirement. Is that correct?
The need to meet senior water rights is a statutory requirement.
You. There's numerous obligations as set forth in your, continuing in that sentence there, including water rights decision D1641. You have the AFRP. You have the biological opinions. Can you tell me the priority at New Maloney's Reservoir for how the project is operated, given the various statutory, regulatory, and contractual obligations?
First of all, I don't believe I listed the AFRP up there. And secondly, if I would refer you to the operations testimony on how New Melones is operated to meet those obligations.
Well, you're the water right person, so I have you. I've talked to the operation people. What I want to know is, from a water right perspective, how you set the priorities for meeting the obligations.
I'm sorry, can you rephrase the question, please?
Yeah, as the water right person, when you have competing statutory, regulatory, and contractual obligations at New Maloney's, how do you, as the water right person, set the priority for allocating the water resources?
Priorities are set by the operations group.
So from the water right perspective, you have no input into how New Maloney's is operated between meeting a ESA obligation under the OCAP biological opinion versus meeting D1641. Is that what you're telling me?
That's basically correct.
Do you know, as you sit here today, whether or not the reclamation meets all D1641 requirements at Vernalis?
For the most part, yes, there are times when, due to hydrology and other factors, we ask for and get relief from the D1641 standards via a temporary urgency change petition.
Is your office currently working on the State Water Resources Control Board temporary urgency change petition order that required reclamation to come up with an operation plan to meet the April-May pulse flow requirement?
The Water Rights Office is not working on the operations plan.
Is the Water Right Department working on the TUCP order regarding the water rights allocations for the TUCP, for the water that was used in 2016?
Objection. I'll just put back on the record the standing objection we have to discussing drought operations and TUCPs as they're beyond the California WaterFix.
Mr. Solberg, answer to the best of your ability. Your objection is noted.
I don't know.
When did you assist Ms. Olson in coming up with the modeling parameters to be used to set forth the flows at Vernalis and how New Maloney's was going to be operated?
Don't know who Ms. Olson is.
Oh, sorry, Ms. White.
No,
sorry.
I didn't.
Sorry. Okay. So who told Ms. White what operating parameters to use in regards to making water available from New Maloney's Reservoir?
I'm afraid you'd have to ask Ms. White that question.
So did you ever tell Ms. White that you have to meet CVP contractors before you meet ESA obligations when you're modeling New Maloney's Reservoir?
I did not have that conversation with her.
Did you have any similar type conversations with her in regards to that?
No.
Is it your understanding that this proposed project is predicated on inflows and outflows to the delta?
Yes, generally.
Okay. And a key inflow component to the delta is the San Joaquin River at Vernalis, correct?
Correct.
Is reclamation amenable then to conditioning its permits at New Maloney's to ensure that the water that has been modeled previously and presented as part of this petition, in fact, is going to be at Vernalis if this petition is approved?
That is a policy decision. That's beyond my pay grade.
Okay. In regards to the water rights in your department, do you deal with the Endangered Species Act and the OCAP biological opinions?
No.
Okay. Who at Reclamation deals with the Endangered Species Act and the OCAP biological opinions in regards to whether or not the RPAs are being met?
That would be the Central Valley Operations Office.
So if I asked you any questions about the current reconsultation occurring under the OCAP BOs, you would not know anything about that, is that correct?
That is correct.
As you sit here today, what is your understanding from a water right perspective of the state? How is the state going to bind reclamation to the commitment in the petition to meet the flows set forth under D1641 in the OCAP biological opinions that were modeled?
Objection, that's compound and assumes facts not in evidence and legal conclusions.
Well, no, I'll rephrase it.
Rephrase it and break it up, Mr. O'Loughlin.
All right, thank you.
I actually want to know the answer to this question.
Yes, I think it's a fascinating question. So what is your understanding of the authority of the State Water Resources Control Board to bind reclamation to meet the D1641 flow components at Vernalis as part of this change petition?
State board.
I'm going to object. This calls for a legal conclusion. He's a water rights expert. He's not an expert on the interchange between the reclamation laws and the board's jurisdiction and whether or not the United States has preemption arguments or has exceeded to the jurisdiction of the state. I think this is well beyond the expertise of this witness. It's not a water rights question.
That's a fascinating statement.
Mr. O'Loughlin, enough.
I know.
Mr. Sahlberg, answer to the best of your ability. If you do not know, you may say you did not know.
I do not
I
know.
would be curious, though, in terms of your expertise as the lead water rights witness for reclamation, if you had not necessarily a legal opinion, but an opinion as a water rights expert in responding to Mr. O'Loughlin's question. Recognizing that although I do not have the advantage of a law degree or being a member of the bar, I often have opinions on water rights matter.
Sorry, Mr. O'Loughlin, after all that, can you repeat your question, please?
No, that's not a problem. So I just want to know, what authority does the State Water Resources Control Board have to bind reclamation to make sure that the flows that you've presented as part of your petition at Vernalis, in fact, show up?
First of all, I'm not quite sure.
Well, let me
what
ask
you
it
mean
a
by
different way.
bind.
Okay, let me ask it a different way. So are you currently aware that the United States Bureau of Reclamation has permit terms and conditions on the New Maloney's projects to meet D1641 flow obligations at Vernalis?
Yes.
Okay. Now, is it your understanding that those permit terms and conditions would continue to occur as this project moved forward?
They would still stay in place, yes.
Okay. And is it based on your previous statement on page 2, it's your understanding that reclamation will meet those obligations in its permit terms and conditions, correct?
Correct.
Okay. So let's move on to the next question, which is the more interesting question. So the more interesting question is it's your understanding that reclamation has a OCAP-BO RPAs for New Maloney's project that included Table 2E, which are the recommended flow requirements for the New Maloney's project. Is that correct?
Yeah, I understand those are in place.
Okay. So my question is, when the modeling was done, the Table 2E flows were included in the model, correct?
Objection asked and answered. We've been through this. The modeling panel has testified at length.
Mr. Loughlin is asking Mr. Sahlberg what he knows, so he may answer.
I do not know if those were included in the model.
Okay. Is it your understanding that the OCAP-BO RPA flows for the New Maloney's project set forth in Table 2E may change over time?
Certainly possible.
Yeah, and in fact, Reclamation's requested a reconsultation under the OCAP-BO opinion, correct?
My understanding.
And so within the next 6 or 9 months, those flows that were set forth in the modeling may change, correct?
They may.
Okay, so here's my question. So if the modeling was done based on Table 2E flows, and Table 2E flows may change under ESA, how is the board going to ensure when it issues its permits for California WaterFix that those flows will show up at Vernalis as set forth in the modeling that you folks have done?
Let's flip that to how will reclamation ensure compliance rather than...
Sure, that's fine with me.
I would say that would be an operations question.
Do you have any understanding as you sit here today how many times the New Maloney's project has violated the February through June flow requirements for D1641?
I do not.
Do you know how many, as you sit here today, do you know how many times the New Maloney's project has violated its permit terms and conditions in meeting the April-May pulse flow?
Not aware of any violations.
Okay. Do you know as you sit here today if how many times the New Maloney's project has violated the permit terms and conditions to meet the October pulse flow?
Not aware of any violations.
And in regards to, do you know if D1641, how many times it's violated the Vernalis salinity requirement?
I'm not aware of any violations.
Are you aware of any requirements in the New Maloney's permits that make it responsible to meet interior delta salinity standards?
There are requirements.
Do you know if those requirements to meet interior delta salinity are on the New Maloney's project permits or on other reclamation permits?
Either on other reclamation permits as well as New Maloney's.
I noticed in your submittal on page 2, and you talked about it previously, there was no discussion of AFRP. Is there a reason why you left out the anadromous fish restoration program?
The list of requirements is not all inclusive.
Okay. Are there AFRP statutory requirements at New Maloney's?
I do not know.
Who would know that?
Central Valley Project Operations Office.
Would it be safe to say too that if in a given year that your office does not determine how much water goes to the Stockton East or Central San Joaquin Water Conservation District under their CVP contracts from New Maloney's?
The allocations are made by the Central Valley Project Operations Office.
Yep. So, going back then, I have one follow-up question in regards to the ESA. Sorry about beating the ESA drum. Mr. Milligan testified that the OCAP BO Table 2E flows would be met, but he stated that the D1641 April-May pulse flows would not be met. Is there a water right reason for that, as far as you know, within reclamation as to why that was done, or why that is being done?
A water right reason?
Mm-hmm. Because you're a water right expert, right?
I believe, I cannot think of a water right reason.
And if I have any questions about the federal supremacy clause, I should direct those to other people at Reclamation other than yourself?
Are we talking the constitutional supremacy clause?
Yeah, in regards to the Endangered Species Act.
Yes, you should.
Okay. Do you have any understanding as you sit here today as a water right expert whether whether ESA and the federal supremacy clause trumps the State Water Resources Control Board permit terms and conditions for D1641?
Objection calls for a legal conclusion.
He may answer that he does not know.
I do not know.
Are you familiar with the permit terms and conditions for New Maloney's project that require the DFW 1988 agreement flows to be met?
Yes.
Okay. Is it Reclamation's position that the permit terms and conditions for the New Maloney's project that call for the DFW agreement flows to be met are subsumed by Table 2E?
I don't know.
Okay. Do you know if they're being met by Table 2E?
I don't know.
Okay. Do you know since 2009 if Reclamation has made any AFRP releases from New Maloney's reservoir?
I don't know.
Do you know if flows are currently being released by Reclamation to meet OCAP BO RPA water temperature objectives on the Stanislaus River?
I object to this line of questioning. He's already testified that operations are not within his division, and
Yeah, but I'm just
I'm
cleaning up. There's
finding-
various components of this that have to be met. I want to just make sure I have a clear record of what Mr. Sahlberg does and doesn't do. This is just one component of OCAP BO.
Let's just go ahead and proceed.
No, I don't know.
Thank you. Turning to page 6 of your testimony, it's the second to the last paragraph, the last sentence.
Okay.
Okay. Mr. Milligan and Ms. Olson both testified that D1641 has not been met and would not be met going forward. So what do you mean by compliance with D1641 will ensure that Delta water users are not impacted by CWF operations?
I'm sorry, can you repeat that question?
Sure. Mr. Milligan and Ms. White, sorry, Ms. White. I keep saying Ms. Olson. I don't know why I say that. I know. I know why I say it.
Focus, Mr. O'Laughlin.
Been in my ear. Okay. Is there a reason why Mr. Milligan, no, sorry. I got thrown off a little bit. Sorry. Mr. Milligan and Ms. Olson both testified that D1641 has not been met and would not be met going forward. So how is it that you state that there will be compliance with D1641? Or what do you mean by compliance with D1641?
Well, my testimony, the sentence you're referring to refers to in-delta water users. I do not know what Mr. Milligan or Ms. White said by they would not be complying with D1641.
So I have a question for you. Is it your view then that if the salinity requirement is being met at Vernalis, that the water in Delta water users are not impacted?
Yes.
Okay. Do you believe, so is it your understanding as a water right attorney that a water right has to do not only with, mainly with quantity and not quality, correct? In other words, it has a point of diversion, a place of use, a maximum rate of diversion, a diversion amount, total amount used. So what it has to really do about is quantity, correct?
First of all, my position is a water rights officer, not a water rights attorney.
Okay.
Second of all, I think your question is a little bit incomplete.
Well, maybe I'll ask it differently. So I'm confused by this statement, and we'll get to it with Ms. Sargent's testimony, because what I'm driving at is it seems to imply that if water quality is being met, that a water right is being met. And do you in your mind make those two the same, water quality and water quantity?
No.
Okay. So in fact, you could have a water quality parameter being met, but if the flows are so low, a water right quantity may not be met, correct?
Hold on a second. Yes. Turn on your microphone, Mr. Sheehan. Mr.
Oh, it's greener, sorry. It's greener. I'm Becky Sheehan for the State Water Contractors, and I would like to object because it's an incomplete hypothetical. Water rights where, water quality where, it's quite vague.
Well, the sentence is quite vague, and I believe that's what Mr. O'Loughlin is trying to get into. So your objection is noted, but I will allow Mr. O'Loughlin a little bit more time to pursue this.
Sorry, I turned off my mic, so I wasn't talking at the same time. So that's the very point. So let's start at Vernalis, maybe. So do you equivocate, do you find that meeting the water quality salinity requirement at Vernalis is the same as fulfilling downstream prior rights, water rights?
Actually, before you answer that, Mr. O'Loughlin, let me see if I can help out and to help me understand. Mr. Stolberg, in the subject sentence that Mr. O'Loughlin is focused on, when you state compliance with D1641, what do you mean by that?
What that means is D1641 has water quality and outflow requirements, among other things. And if we comply with basically the outflow requirements, the in-delta uses will be met as a function of meeting those outflow requirements. The water comes in,
So
they they're under their rights, and if by those diversions outflow drops, then we do what we need to do to make sure that the outflow requirements are met. That's what that sentence means.
So in this sentence, in this part of your testimony, you are not focusing on just the water quality requirements of D1641.
Correct.
Thank you.
So this includes a quantity component, correct?
Yes.
Okay. So basically then, as I envision it, there's enough water moving through the delta that it's going to meet the quantity needs and the quality needs, because in order to push water out through delta outflow, there's enough water in the system, correct?
Correct.
Okay. And we put up in my submittals, I think it's number 14, State Water Contractors Complaint. So, are you familiar, Mr. Sahlberg, with the State Water Project contractor complaint that was filed with the State Water Resources Control Board alleging that there was illegal diversions in the Delta?
I know they filed a complaint. I'm not familiar with the particulars of it.
Okay. Well, how do you reconcile your statement that you just made to the board that when you're releasing water to meet Delta inflow and outflow, that these water rights in the Delta are being met?
Objection, relevance.
I'm sorry, Mr. Mizell?
Objection, relevance. The state water contractor's complaint is not proposing to speak for either the department or reclamation. It was done under their own authority. And to say how our witnesses need to somehow reconcile the proposal under the California WaterFix with what the state water contractors have put forward really isn't germane to this hearing.
Well,
Would you like to restate your question, Mr. O'Loughlin?
No, I don't. I think it's a perfectly great question, and here's the reason why. So the problem here is just this. I know. I'm sorry. I should tone it down a little bit.
Then you would not be Mr. O'Loughlin we all know and not quite love.
Okay. So here's. You're driving me crazy.
I have missed you.
You know, that line from you a couple weeks ago is posted in my office. You're driving me crazy, but not in a good way. Okay, so that's posted in my office. Okay, getting back to trying to be serious. Okay, so this is a very fascinating point because if you read the testimony that's being presented, the testimony is presented in terms of water quality and water quality parameters being met. So, actually, Mr. Sahlberg said that if water quality is being met, there's enough flow going through the Delta that it's meeting these rights. But what's interesting about the modeling that was done is if you assume that water is being released, and we'll get to this with Ms. Sargent in a bit about stored water, well, wait a second. They are saying that that water is exclusively theirs. So right away, I'm not saying this is true. I'm not saying it's correct. All I'm saying is that people believe that there's a 200 to 400,000 acre foot hit in the Delta from people taking water that shouldn't be entitled to it. And based on that, how you run the projects and how you model the projects for meeting demands in the Delta are entirely different. That's the point.
So, Mr. O'Loughlin, what was your question again?
Okay, I'll try to rephrase it. So, well, you know what? Maybe I'll go a different way. So, if I understood your statement correctly, you're not familiar with this complaint. Is that correct?
That's correct.
Give me a couple minutes. I want to make sure that I run through my list of questions for Mr. Sahlberg, and then I'm completed. How could I forget? Okay, so have you reviewed the draft water quality control plan, SED, that has been put out by the State Water Resources Control Board last week?
No.
Have you previously reviewed the draft water quality control plan, SED, that was put out in 2012?
The Water Rights Group reviewed it, yes.
And would that include you?
Yes.
Okay. Do you have any understanding why in the draft EIR EIS that the water quality control plan SED from 2012 was not included?
Included where?
Why in the draft EIR EIS
No,
for
I
California
don't.
WaterFix?
No, I don't.
Do you have any understanding as you sit here today from a water right perspective what the operations at New Maloney's would look like in regards to the 2012 draft for New Maloney's project operations?
No, I don't.
Do you have any understanding as you sit here today that Table 2E flows would have priority over water quality control plan unimpaired flows?
I'm sorry, can you repeat the question?
Yeah, do you have any understanding as you sit here today from a water right perspective if Table 2E flows would have priority over water quality control plan unimpaired flows?
No, I don't.
Were you familiar with the submittal by the Department of Interior and Reclamation for the 2012 Water Quality Control Plan SED?
It's been a long time since I've looked at it.
Okay. Do you have any understanding of what Reclamation's position is on the priority of water being released from New Maloney's reservoir in regards to unimpaired flow?
I don't recall.
Do you have any understanding if Reclamation will be able to meet and I'll use the old one, the 2012 35% unimpaired flow, and maintain the modeled flows at Vernalis that are part of this petition?
No, I don't.
Do you know how, if you know, under water rights, that Reclamation will meet the carryover storage requirements under the proposed water quality control plan and still meet the modeled flows that are part of this petition?
No, I don't.
Thank you.
If we're going to be switching
Hold on,
different
Mr.
area,
Berliner.
wondering if this might be an appropriate time for a break if we're switching to a different area, if that's convenient for Mr. O'Laughlin.
Perfectly fine with me. It's up to the hearing
Okay,
officer.
let's go ahead and take our 10-minute break. We will resume at 10:56. If you could please take your seats. We will resume now, and I'm actually 1 minute late. Mr. O'Loughlin, please continue.
Thank you. I have questions now for Ms. Sargent. When you were drafting your declaration, did you look at the water code to ascertain what is a injury to any other legal user of water?
I'm generally familiar with the provisions. I didn't specifically go back to the water code before I prepared my testimony.
Do you know if change petitions are generally governed by Chapter 10, Section 1700 of the Water Code?
Generally?
Do you have an opinion, as you sit here today, as to whether or not the language in Water Code Section 1701 2D should be interpreted the same as the language in 1727B1 governing temporary changes in points of diversion, place of use? Sorry, oh, sorry. Don't worry, I'll go back. I'm sorry, way too fast. Should be interpreted as the same as the language in Water Code Section 1727B1 governing temporary changes in points of diversion.
I don't have an opinion as interpreting various provisions of the water code.
They both state that they would not injure any legal user of water. Do you understand that those conditions are to be interpreted and applied the same for both a change petition and a temporary transfer?
I don't have an opinion as to that.
Do you think that they should be treated differently?
Objection asked and answered.
Mr. O'Loughlin, she's already answered that. You're not going to get an interpretation out of her.
With regard to the rule against injuring any other legal user of water, is there a difference in your mind factually between changing a point of diversion and a water transfer?
I'm sorry, I'm not.
Sure. Is there a
What you're asking for.
is there a factual difference between changing a point of diversion and a water transfer as it applies to any legal and injuring other legal users of water?
I'm not prepared to give you any interpretations as to different provisions or comparing the current petition to water transfers.
Okay.
For this petition, I tried to evaluate the information available to see if there were changes that might impact the ability of other legal users to use their water.
Are you a water right attorney?
I am not.
Are you an attorney?
I am not. I'm an engineer.
Have you?
Woohoo!
Yeah, that scores a couple points. Okay, so we'll give you two.
That line of question.
Did you review any State Water Resources Control Board cases as to the definition of injury to other legal users of water in preparing your testimony?
Excuse me, State Water Resources Control Board cases? Are you referring to legal cases?
Yes.
I did not.
Okay. Did you refer to any State Water Resources Control Board orders regarding injury to other legal user of water?
I have reviewed State Water Resource Control Board orders, a number of orders over the course of my time working in water rights for the State Water Project.
Were you present when either Mr. Lehigh or Mr. Milligan testified?
I was not present, but I did watch portions of the testimony.
Okay. Specifically, I asked Mr. Lehigh and Mr. Milligan if reservoir storage would change daily or monthly, and they both agreed. Do you agree with that statement by those two individuals?
Based on my review of the information provided by the modelers the graphics provided by the modelers, I agree
Okay.
that there may be some temporal changes.
Right. But generally, end of month storage September was the same or better, correct?
That's my recollection, yes.
The other thing I asked Mr. Lehigh about and Mr. Milligan, and I don't know if you've talked about this, on page 11's line 10 to 15, you opined that it is my understanding that such water users do not have a right to stored water releases from the CVP. Is it your understanding, Mr. Milligan and Mr. Lehigh both testified that water other than stored water would be being released by the projects. Is that your understanding?
It is my understanding that the projects release both components of inflow as well as storage.
Okay. So in regards to line 12, you state it seems to imply that the only water being released from the reservoirs is stored water, and that's just not right, right?
I believe that mischaracterizes my testimony.
Okay, so why don't you tell me what you meant then, that this would not injure other legal users, because it is my understanding that such water users do not have a right to stored water releases from this SWP CVP.
My testimony refers to water stored under DWR's water rights.
Okay, so are you only talking then that water being released from the reservoirs? Well, maybe I'll ask it a different way. How do you then reconcile this statement with Mr. Sahlberg's statement that the amount of water entering the delta and meeting delta outflow satisfies under all conditions water users in the delta?
I'm sorry, I'm not understanding your question. My testimony relates to the rights, whether or not other water users have a right to project storage. It doesn't describe anything related to inflows to the delta.
No, but what I'm
natural
trying to
flow.
get at is, do you understand that stored water is released from Oroville to meet delta water quality requirements?
Yes,
Okay. And your testimony is that delta water quality components under D1641 will always be met, correct?
my testimony is that DWR and Reclamation will continue to operate to meet D1641 objectives. Mr. Lehigh spent quite a bit of time describing how we operate to meet those objectives, but there are times when meeting those objectives is not possible due to hydrologic or meteorological conditions.
Okay, so my question is this though. So Mr. Sahlberg just stated earlier that if water is entering the delta to meet water quality, that water would also meet the in-delta demands. Are you saying that in this statement here that the people in the delta are not entitled to the stored water that's being released to meet water quality in the delta?
My testimony is that no other water users have a right to the storage releases. Storage releases are made to maintain water quality, and at times, I believe later in my testimony, I describe how those releases maintain a water quality that would be better than what would exist absent those storage releases. DWR does not make a determination as to all the diverters in the delta, whether or not, what the basis of their right to divert is. They release water quality or make releases to maintain the objectives in D1641, which were adopted to protect other legal users. It's the board's job to determine who those legal users are.
Well, what I'm trying to get at though, oh, I'm sorry. Am I done?
Yes.
Oh, okay. Thank God.
Did you want to finish this line of questioning?
Oh, yeah, I have it's about a half hour, hopefully, not more than that.
Just on this line of questioning?
Oh, no, altogether.
Okay. Can you do it in 15?
Probably not. I'm not that good.
Oh, you can do it. You can do it. Let's give him 15, and we'll go with that.
Okay. Well, what I'm trying to understand here is that you make a statement that there's not going to be an injury to any legal user of water in the Delta, but then you just said that you've made no determination as to who has what rights in the Delta to divert what water. So how do you reconcile those two?
I don't believe those two are related. We make releases to meet our the water quality objectives that the board has determined are sufficient to meet the beneficial uses. So if we are meeting the objectives that are necessary for diverters in the Delta to put that water to beneficial use, that protects those diverters in the Delta that have a legal right to divert.
Well, are you familiar with the exhibit that I previously showed about the state water contractor's complaint to the State Water Resources Control Board?
I have read it, but I was not
Okay.
part of it.
So how do you reconcile their belief that water is being taken illegally in the Delta with your statement that if water quality is being met, in Delta demands are being satisfied?
I believe those two don't have anything to do with each other. The contractors have a complaint related to whether or not there are some diverters in the Delta that are diverting illegally. The department is not making any of those determinations. We are releasing water to meet our objectives, and it provides a water quality in the Delta that's sufficient to allow those with valid water rights to divert.
So at what point in time does DWR abandon the water that is being used to meet the water quality control plan, water quality objectives in the Delta?
We do not abandon the water that's released for water quality objectives.
Okay. Can you point to some place where I can find it where there is a state board order that protects that water as it moves through the system so that it is not abandoned by DWR?
Objection, relevance.
Sorry, never mind.
This goes to current operations. This is not the California WaterFix.
Ms. Sargent, just answer to the best of your ability. You're doing a good job as it is.
DWR has made it clear on a number of occasions that it does not abandon the water that it's released. Water quality and fisheries objectives are beneficial uses listed in the State Water Project water rights. We release water for those purposes. The Water Board has, in some of its reasoning, in the most recent, including the most recent approvals of the temporary urgency changes, that the other diverters are not entitled to the releases made to meet water quality objectives. D60 or D1594 was an effort by the department. I'm sorry, Water Right Decision 1594, I'll try to slow down, was an effort by DWR and Reclamation to protect their releases made for water quality objectives. A number of the contracts specifically state that the place of use within the Delta is water's not to be moved outside the Delta to the detriment of potential return flows. There have been a number of cases where DWR has made an effort to protect those storage releases.
Okay. Where in D1641 does it say that the water that's being released to meet Delta water quality parameters is protected?
It's not an element of D1641. It was not an issue that I recall being addressed in D1641. The water quality, again, the water is released to make for specific beneficial purposes that are listed in DWR's permits, and DWR does not abandon the water, those flows that are released for that purpose.
So how does DWR recapture the water that's being released to meet X2?
I didn't say that DWR recaptures the water. I said it's protected because it is as required to meet the beneficial purpose for which it's released.
So can you point me to something in the Port of Cologne Act that equates meeting a water quality requirement to a water right permit term or condition?
Objection, calls for a legal conclusion.
If she knows.
I cannot.
Okay. Can you ascertain or tell me why Water Code Section 1707 exists if your statement is true and correct regarding your belief that the water is not abandoned until it meets delta outflow?
Objection calls for a legal conclusion.
If you know.
Mr. O'Loughlin, this is,
Well, no, but this is a very important point, and I'll tell you why. I know you're giving me time to do this, but the important point here is this. The statements being made by DWR in regards to what water is being released at what time to meet what condition is extremely important to understand whether or not there is an injury to a legal user of water downstream. And I fully understand DWR's position that if stored water is being released, no one downstream has a right to divert such stored water until it meets a water quality control plan requirement. Now, I'm just I'm almost done with this, and I just have a few more. We'll get her understanding, and I'll move on, and then we'll make the legal argument at a later date about whether or not that's true. I have no problem with that.
okay. You anticipated my direction to you. There's only so much I believe Ms. Surgeon will provide. So let's get to the chase and let's move on.
It's my understanding that Water Code Section 1707 was implemented to allow diverters to dedicate water for in-stream purposes and to protect that downstream. They do not have those listed purposes within their water rights. DWR's water rights all contain beneficial uses of salinity control and fishery and wildlife purposes. Water is released specifically to meet the requirements. Outflow is not something that is satisfied until you exit the delta. It's also, the board has determined the outflow objective or the inflow objectives for the San Francisco Bay Area. So those objectives in the Water Quality Control Plan for outflow were related to inflow to the delta, and it's DWR's position that no water is abandoned at any point within the delta that is released for those purposes.
Thank you. So I want to turn our attention to the reservoir operations. Can you put up my exhibit number 12, DWR white paper, please?
Is it SJTA 12?
Please. In your testimony, you stated as under your curriculum vitae that you helped draft the white paper. Is that correct?
That's correct.
Okay. And you're familiar with the white paper, correct?
Yes, I am.
Okay. And you deal with this on a yearly basis, this document. Is that correct?
Depending on the year.
Yep. Okay. Can you scroll down to the next page? Okay. Are you familiar with the term refill requirement as set forth in the white paper for DWR?
Yes, I am.
Objection. Relevance. This document is talking about transfers. That's not part of the California WaterFix at this time. We're not proposing any transfers. And although it's listed on Ms. Surgeon's CV, that does not in and of itself make it relevant to this hearing.
Mr. O'Loughlin?
Sure. Actually, this is why I asked the questions early on between the difference between injury under diversions and under transfers and how they're treated by the State Water Resources Control Board. So bear with me.
I always do.
Our position is that injury to legal user of water under the transfer position and under the change petitions are treated exactly identical by the State Water Resources Control Board. So what we will be talking about here is that if the reservoirs go lower and then they're refilled, how that impacts downstream senior water right holders that may have been entitled to the water that was captured under these monthly operation scenarios that otherwise wouldn't have been, and what the impacts to those senior water right holders would be.
I'll allow it.
Okay. So can you describe for the board what your understanding of refill is?
Yes. When a party proposes to make a transfer that is based on releasing water from their reservoir that is in excess of what would be needed to meet the demands within their service area, that creates a hole in the reservoir that would not exist absent the transfer and absent moving water outside their authorized place of use. And in the following year, if that water is refilled at a time when other water users downstream have a demand for that water, it could result in a reduction in the stream flow that would not exist absent the transfer.
Okay. Thank you. Now, when you were doing your analysis, did you look at the amount of water that was being refilled in the reservoirs in these temporal months that we talked about earlier? Did you look at that actual amount of quantity of water?
I'd like to clarify something.
Sure.
This refill criteria relates to transfers. It relates specifically to water that is released for a transfer that is in excess of the water that is needed within the service area or to meet the requirements of the permits. The California WaterFix has nothing to do with transferring water to any other user outside the State Water Project place of use or using water for a purpose that is outside the existing permits. The water levels that are shown in the modeling results are well within the normal operating criteria of the State Water Project, and any fluctuation in the water rights or in the upstream, I apologize, I'll try to slow down, in the upstream reservoirs is not related to any change that is outside the normal operating criteria of the projects. So this refill does not apply. The refill criteria would not apply to the WaterFix in any way.
Well, I'd move to strike, but I'm not in the mood for it. So can I just have an answer to my question? Did you look at the amount of water that went into the reservoirs during these months due to the drawdown? Yes or no?
I looked at the graphs that were provided by the modeling group, yes.
Did you ascertain the quantities of water in any month that were being refilled into the reservoir that otherwise wouldn't have been refilled into the reservoir due to the California WaterFix?
I did not distinguish if for any particular month what the refill would have been. The reason I did that is neither the State Water Project nor the CVP diverts water to its reservoirs at a time when other legal users downstream have a demand for that water. All the demands downstream are being met.
So the answer is no.
The answer is I looked at it and I did not consider it to be a potential impact because we only divert water to storage at times when all downstream demands are being met. That is the typical time, say, if you're trying to compare this to the refill criteria, with refill criteria, that upstream user that created the hole for a transfer can only refill that hole at times when all downstream use is being met. So by the nature of DWR's water rights and the requirements that we have, DWR is only diverting water to storage under all conditions at times when all downstream uses are being met. So there wouldn't be any reason to have a refill requirement on any operational change at an SWP reservoir because by its very nature, the permits allow us to divert water at times when there is excess flow available. And we don't divert water if it would mean that there is a demand downstream that can't be met at that time.
Okay, moving on. Can you put up exhibits 3 from the SJTA, please? When you were doing your analysis to ascertain injury to any legal user of water, did you look at the demand of downstream riparians or senior water right holders at times when your reservoirs were putting water into storage due to these temporal changes?
I believe my last answer is still applicable, and it addresses your current question.
Okay, so the answer would be you've not looked or ascertained what downstream water rights are or the demands were at any time during the year. Is that correct?
My answer is that we only divert water at times when all downstream demands are being met.
And if that was factually incorrect, then would your statement still hold that there is no injury to legal user of water?
I don't believe my answer is factually incorrect.
No, I know, but if it is,
No, Mr. O'Loughlin, let's not go there.
well, it's a simple question. If it goes to the essence
No,
of her
Mr.
opinion.
O'Loughlin.
Well, wait, it
Move
goes
on.
to the essence. No, but this is a very important point in regards to where we go with California WaterFix, because if she's incorrect in her factual statement, okay, then does her opinion that there is an injury to legal user of water still stand? It may stand on other bases or for other reasons, but for this very important factual point, it's extremely relevant to understand how that fits in with her opinion, because quite frankly, right now, it's the entire basis of her opinion.
Mr. O'Loughlin, enough. Ms. Surgeon, just one more time for the record.
I don't believe my statement is factually incorrect.
All right. Mr. O'Loughlin, please wrap up. Was there any line of questioning?
One last one.
Okay.
I want to, in your testimony, it seems to imply, and I raised this point with Mr. Sahlberg as well, do you equate water quality and water quantity as the same thing?
No.
Okay, thank you. No further questions.
Thank you, Mr. O'Loughlin.
Thank you.
State water contractor, Ms. Sheehan, do you have cross-examination?
Morning, I'm Becky Sheehan for the State Water Contractors, and we do not have any cross-examination of this panel.
Thank you. Group number 4, San Luis and Delta Mendota.
Sorry.
Ms. Ackroyd? Yes. Okay. What are your lines of questioning, and how much time do you anticipate needing?
I anticipate less than 20 minutes of questioning. And in terms of the summary, a number of the protestants are CVP contractors, so I intend to ask Mr. Sahlberg some questions regarding what their contracts provide regarding both storage and shortages. The reason for that is we believe that given the terms of some of the contracts, some of the injuries they are complaining of may not be legal injuries under the Water Code.
Okay, proceed.
Morning, Mr. Sahlberg.
Good morning.
First, I'd like to see if we can bring up Exhibit DOI 9, which is a table listing CVP contracts. Thank you. Mr. Sahlberg, are you familiar with this table?
Yes.
This table shows all of Reclamation's CVP water contracts broken into groups, correct?
Correct.
I'm going to ask you a series of questions regarding provisions in these various groups of contracts. First, page 1 of this table lists a number of water service contracts for North of Delta CVP contractors, correct?
Correct.
Do the North of Delta CVP water service contracts include any provisions requiring Reclamation to maintain any specific minimum storage levels in its reservoirs?
They do not.
Going to the next page, please, page 2. Page 2 of the table identifies North of Delta American River M&I contracts. Do any of the contracts listed here require Reclamation to maintain any specific minimum storage levels in its reservoirs?
They do not.
I'd like to object to that question. It's incomplete.
Identify yourself for the record.
Ryan Becerra, Barkowitz, Chronic, and Shanahan for cities of Folsom, City of Roseville, San Juan Water District, Sac Suburban Water District.
Slow
sorry.
down.
I apologize.
Mr. Rivera is representing part of Group 7. Let's just put it that way.
Ryan Becerra, Barkowitz, Chronic, and Shanahan for the cities of Folsom, Roseville, San Juan Water District, Sacramento Suburban Water District. We'll bring this out in cross-examination. We've done it already. All these contracts are subject to the terms and conditions of Reclamation's water right permits for its operation of its facilities, including Folsom Reservoir. Those water right permits have terms and conditions regarding the protection of American River contractors. So the question is objectionable in that it mischaracterizes the evidence, it mischaracterizes the content of the contracts and how they are subject to water right permit terms and conditions.
Ms. Ackroyd, please rephrase your question.
First, in response to the objection, I believe it's relevant because as I kind of gave in my
I'm
summary.
allowing you to ask the question, just rephrase it.
Perhaps narrowing the question slightly, focusing solely on the terms of the contracts and not the permit terms, which Mr. Becerra said he may address. Already coming back.
Mr. Becerra?
Yes, I'd like to object on best evidence grounds. She is asking a question about the contents of these contracts without presenting the contracts themselves. The contracts refer to multiple they refer to water right permit terms and conditions. They also refer to various acts of Congress. So asking all of these questions about what these contracts contain without presenting the contracts themselves is objectionable under best evidence grounds.
I'll note your objection, but I'm going to allow her to proceed, and the witnesses will answer to the best of their ability. If they're not familiar with something, I'm sure they'll say so.
And we will, in some of the questions as I proceed, be opening up specific contracts and looking at very specific contracts, asking if those are representative of others within the group. But for this line of questioning, if Mr. Sahlberg needs to ask to open, we can do so. Thank you. So going back to the question, for this list of contracts, which are north of Delta, American River, M&I contracts, are you aware of whether any of the contracts listed here require reclamation to maintain any specific minimum storage levels in its reservoirs?
They do not.
Go on to the next page, please, page 3. Pages 3 through 6 of this table list the Sacramento River settlement contracts. Same question. Are you aware whether any of these contracts include provisions requiring reclamation to maintain any specific minimum storage levels in its reservoirs?
They do not.
And please proceed to page 7. Pages 7 through 11 list a number of additional contracts for other service areas, correct?
Correct.
Are you aware whether any of these CVP contracts include provisions requiring reclamation to maintain any specific minimum storage levels in its reservoirs?
They do not.
Thank you. And I'd like to turn briefly to several specific contracts that involve the use of Folsom Reservoir but do not involve CVP water. First, I'd like to have Exhibit SJWD 14 brought up.
Mr. Becerra?
Just anticipating the possibility of objecting.
Mr. Sahlberg, SJWD 14 is a Warren Act contract between the United States and San Juan Water District, correct?
Correct.
What is your understanding of what a Warren Act contract is?
Warren Act contract provides for the use of federal facilities to store and convey non-project water. In other words, water that is not appropriated under a reclamation water right.
Do you know whether this contract requires reclamation to maintain a specific minimum storage level in Folsom Reservoir?
Mr. Becerra?
Again, objection on best evidence grounds. The contract is in the record and she's asking for a characterization of its terms.
She's asking an expert witness for his expert opinion. Answer, please, Mr. Sahlberg.
I'm not aware of any such provision.
Thank you. We can bring up next Roseville 11. Scroll down a little. Thank you. Roseville 11 is a contract for conveyance of non-project water between the United States and City of Roseville. This, again, is a Warren Act contract between the United States and now the City of Roseville, correct?
Correct.
Does this contract require reclamation to maintain a specific minimum storage level in Folsom Reservoir?
Objection, best evidence grounds.
We'll just make that a standing objection so that you don't have to keep coming up,
Thank you.
and I can keep overruling you. Please answer.
No, it does not contain any such provision.
And are you aware of any other Warren Act contracts that involve the use of Folsom Reservoir?
No, I'm not.
Fine. Next, I'd like to have Exhibit DOI 25 brought up. DOI 25 is a contract between the United States and the City of Folsom for the conveyance of water rights water. Is that correct?
Yes.
You can please go to page 9 of the document. We're looking for Article 3D. I'm trying to remember whether it's 9 of the PDF or 9 of the interior numbers. So right there, perfect. Thank you. So looking at Article 3D, which is on the screen, does the contract require reclamation to make all reasonable efforts consistent with the overall operation of the project to maintain sufficient flows and levels of water from the Folsom Reservoir?
That's what it says.
Objection. This misstates the evidence. She's calling out one section of the contract and asking what the contract then requires. If we're going to go down this route, we need to deal with the entire contract, which deals with Folsom, City of Folsom's pre-CVP water rights.
So noted, Ms. Akhtarai.
Thank you. And where I'll be going with this is going to be asking several questions again regarding Mr. Sahlberg's opinion and his understanding of this contract. Thank you. Does this contract, are you aware whether this contract further defines what reasonable efforts are?
No, it does not.
Are you aware whether the contract defines consistent with the overall operation of the project?
No, it does not.
On that point, were you here when Mr. Milligan testified for Interior?
Yes, I was.
Did Mr. Milligan describe the considerations that go into operating Folsom Reservoir consistent with CVP project purposes?
Yes, he did.
Thank you. Now turning back to Article 3D, does the Folsom contract further define what sufficient flows and levels are?
No, it does not.
Do you know whether this contract requires reclamation to maintain any specific elevation in Folsom Reservoir?
It does not.
Does this contract require reclamation to maintain any specific quantity of storage in Folsom Reservoir?
No, it does not.
Thank you. I'd like to switch gears a little bit and turn to the so-called shortage provisions that are in many of Reclamation CVP contracts. Reclamation CVP contracts. But first, in your testimony and presentation, you described how Reclamation provides CVP water pursuant to a number of different types of CVP contracts, water service, settlement, exchange, et cetera, correct?
Correct.
Thank you. These different types of contracts often include different types of contract provisions, correct?
Yes, they do.
I'd like to focus now on the shortage provisions in CVP water service contracts. First, what is your understanding of what is meant by a shortage provision?
Storage provision in a CVP contract states that the United States is not liable if it does not provide full contract quantity for a number of reasons.
Thank you. I'd like to look at a specific example. If you can open up DOI 15. Reclamation has identified this as a sample water service contract for the Sacramento River Division. It's a contract between the United States and Orland Artois Water District. If you can please scroll to Article 12 of the contract, which I believe is at page 30 of the PDF. There we go. It's fine. I'm going to be focusing on Article 12B, right? So that's the right page. Thank you. Please read or look at Article 12B. Sorry, it's the next page. Thank you. If you can read that to yourself and let me know when you're done.
Okay.
Consistent with your explanation before of a shortage provision, does subdivision 12B identify possible causes of shortages?
Yes, it does.
And are actions taken by the contracting officer to meet legal obligations a possible cause of shortage?
Yes, they are.
Do actions taken to meet legal obligations include actions taken to meet federal statutory requirements such as the ESA?
Yes.
And do actions taken to meet legal obligations also include actions taken to meet the terms and conditions of water rights permits issued by the State Water Board?
Yes.
Subdivision 12B states that when conditions of shortage occur, no liability shall accrue against the United States, correct?
Correct.
Is it your understanding that a number of the different categories of CVP contracts include similar shortage provisions?
The water service, yes. Almost all CVP contracts have some type of shortage provision.
And is the shortage provision in this sample Sacramento River Division water service contract representative of shortage provisions in other Sacramento River Division water service contracts?
Yes, it is.
Is it also representative of shortage provisions in water service contracts for other divisions of the CVP?
Yes, it is.
Switching gears again slightly, is there any provision in the water service contracts entitling contractors north of the Delta to a higher percentage allocation of CVP water than water service contractors south of the Delta?
No, there is not.
Next, I'd like to turn to a different subset of contracts, the Sacramento settlement contracts. If you can please bring up Exhibit DOI 11. DOI 11 has been identified by Reclamation as a sample settlement contract, and it is a contract between the United States and Maxwell Irrigation District, correct?
Yes.
You can please turn to Article 3I, which is at page 11 of the contract. Oh, I might be wrong there. Oh, sorry, 11 of the contract, so it'll say 11 at the bottom of the page, so it's probably further along. Next page. I, perfect. So at the very top of the screen there. If you can please review that and then let me know when you've completed.
Just for the record, it's page 12 of the contract.
Oh, sorry, my mistake.
Okay, I'm done.
Similar to the shortage provision we already discussed, this provision excuses Reclamation from liability for shortages of project water because of actions taken to meet legal obligations, correct?
Correct.
And is this provision representative of the shortage provision and in the other Sacramento settlement contracts?
It is.
Thank you. Nothing further.
Thank you, Ms. Ackroyd. Group number 5, Mr. Williams.
Good morning, Philip Williams, Deputy General Counsel for Westlands Water District. I see Mr. Becerra walking back up. So.
He's filling in for Ms. Morris today in terms of the pouncing.
Ms. Morris may object to the characterization. But
your line of questioning and time estimate, Mr. Williams?
Yes, ma'am. I expect to take about 15 minutes.
And you'll be exploring?
On August 10th, Mr. Lilly presented a document regarding Term 11 of certain permits regarding Folsom Reservoir. The intent of my line of questioning will be to fully elucidate what protections that Term 11 provides.
Okay.
Mr. Sahlberg, my questions will be directed mostly at you, sir.
Okay.
Mr. Baker, would you please pull up Westlands Water District 7? This is State Water Resources Control Board Water Rights Permit 11315. Mr. Sahlberg, are you familiar with this permit?
Yes.
Mr. Baker, would you please pull up Westlands 8? Mr. Sahlberg, are you familiar with this permit?
Yes, I am.
Both of these permits contain terms, one of which in each is term 11, correct?
Correct.
Would you like to scroll through to make sure, or are you confident in that?
I'm confident.
Mr. Baker, would you please pull up BKS 1? And I apologize, it's not, there it is. Mr. Sahlberg, please look at the highlighted sections. If you could scroll down, Mr. Baker. Mr. Sahlberg, if you would read to yourself first the highlighted section on the first page, and then the highlighted second page on the second page.
Okay, I'm done with number 11. Is there another one?
Would you go down to the second page, please, Mr. Baker?
And for the record, as he's doing that, this is an excerpt from,
This is BKS 1, and I understand this is an excerpt from the 2 permits that I just presented.
okay.
Okay.
The 2 highlighted paragraphs are identical in language, are they not?
Yes, they are.
Mr. Baker, would you please pull up Roseville 5? I'm sorry, yeah, Roseville 5, it's on there as Westlands.B, if everyone trusts me. Well, are you familiar with Decision 893, sir?
Yes, I am.
To your knowledge, what was the historical trigger for Decision 893?
Briefly, Decision 893 is a water rights decision on various applications to appropriate water from the American River filed by numerous parties, City of Sacramento, El Dorado County, Georgetown Divide Utility District, I think, and of course the United States, among others.
And this decision provided terms and conditions for certain permits that issued from that decision, is that correct?
That's correct.
Mr. Baker, would you please pull up Westlands 9? Westlands 9 contains term 14 for applications 13370 and 13371. It is page 72 of Decision 893. And I will refer to this just as term 14. Are you familiar with term 14, sir?
Yes, I am.
Would you please read it to yourself?
Okay.
I just asked you to read to yourself term 11 from BKS 1. Term 14, as it appears here, is nearly identical to term 11. Is that correct?
That's correct.
In fact, the only real difference is its specific application to the permits in question.
Correct.
So, sir, just so we're all clear on the progression, the relationship here, Westland submitted 2 applications that resulted in D893 inside.
Sorry.
I'm sorry, reclamation.
Yeah.
What did I say? I said Westlands. We're going to do that tomorrow. Reclamation submitted 2 applications, which resulted in Decision 893 being issued. Inside that decision was term 14, correct?
Yes.
And D893 included this term, which included for permits to be included in permits 11315 and 11316.
Correct.
And I want to turn to the substance of term 14. It provides a protection for Placer, Sacramento, and San Joaquin counties, does it not?
Yes.
And is it your understanding that the protection this affords is that the delivery of water pursuant to the permits in question shall not be made beyond the counties in question until the needs of those counties are met, provided, however, that those parties enter into contracts with reclamation by July 1st, 1968?
Yes, that's correct.
So the protection provided was contingent upon the parties entering into contracts prior to July 1968.
Yes, that's correct.
Objection.
Mr. Becerra?
Yeah, it actually misstates the effect of the term because in a later decision, I believe it was D
was one-
1356.
Yes, sir.
The board later extended the date to 1975, I think.
December 31st,
Mr. Williams?
And I'm going to get there. Are you from, so some of the parties in these counties entered into contracts prior to this date, is that correct?
That's correct.
And are you familiar with some of these contracts?
Yes.
And those contracts would contain the kind of shortage provisions as you just discussed with Ms. Aykroyd, which are typically found in reclamation water service contracts, correct?
Hold on, Mr. Becerra?
Objection, best evidence misstates the evidence. We're talking about the terms of specific water service contracts, all of which, I believe, state that they are subject to reclamation's compliance with all water right terms and conditions that apply to the Central Valley project.
Mr. Williams?
I don't, do you want me to respond to that, ma'am, or just go? I'm speaking to specifically to term 11 in the permits.
So let's focus on that.
In the permits. Yes, ma'am. So going to Mr. Becerra's point, in fact, the deadline in term 14 was extended, was it not?
That's correct.
And it was extended to December 31st, 1975, correct?
Correct.
And it was decision 1356 that extended that deadline, correct?
Yes, it did.
Mr. Baker, would you please pull up Westland's 11? I will refer to this as term 19. You see that in the center there. This is page 16 of decision 1356. We've already established that term 19 provided for the extension of term 14, correct?
Correct.
Did term 19 here in any other way modify term 14 of decision 893?
No.
Mr. Baker, would you please pull up Westland's 12? Westland's 12 is Water Rights Order 70, amending and affirming Water Rights Decision 1356. Are you familiar with Water Rights Order 70, sir?
Yes.
Mr. Baker, will you please pull up Westland's 13? This is page 7 of Order 70. This water rights order ordered that paragraph 19 be deleted, did it not?
Yes, it did.
By paragraph 19, I mean term 19 of D1356.
Correct.
The effect of that deletion was to reinstate the deadline of July 1st, 1968, correct?
Correct.
Are you aware of the bases for that decision, or that deletion, excuse me?
I believe the board said that the protections or preference provided by term 19 was no longer necessary, and that the parties seeking water within those three counties had other means to obtain a supply, such as filing for a water right. Generally, that's it.
Thank you. To your knowledge, sir, no other order or decision issuing forth from the State Board has modified term 14. Is that correct?
That's correct.
So I just want to summarize and make sure that I'd ask you to make sure to confirm or deny. Term 14, as properly and fully understood, prevented the delivery of water outside the counties in question, here them being Placer, Sacramento, and San Joaquin, until July 1st, 1968, the date which the board set for parties within those counties to enter into contracts for the delivery of the water in question. Do you agree with that?
Yes.
And that therefore, because term 14 of D893 and term 11, as found in permits 11315 and 11316, are nearly identical, term 11 is best understood to mean the same.
Yes.
Thank you, sir.
Mr. Becerra?
Object to the question. As long as it's we're dealing with Mr. Sahlberg's understanding, that's fine.
And I don't mean to indicate otherwise.
So noted.
Thank you, ma'am. I have no further questions.
Thank you, Mr. Williams. That was interesting. And about the only reason I allowed for that friendly cross-examination from you and as well as Ms. Ackroyd. With that, let's go ahead and take our lunch break, and we will resume at 1 o'clock. All right, welcome back, everyone. It's 1 o'clock, and we will resume cross-examination of the water rights panel. Group number 6. Is anyone here from group number 6? Not seeing anyone. Group number 7, you're up for cross-exam. Microphone and identify
go.
yourself.
Andrew Hitchings on behalf of Protestants Glenn-Calusa Irrigation District and Biggs West Gridley Water District. For Group 7, we just wanted to apprise you of the approach that we intended to take. I was going to go first. I have some very specific questions with regard to some of the settlement contract characterizations in the testimony. I would then be followed by Mr. Cooper. And he, at the beginning of his cross-examination, he could take you through the summary of the areas that he's going to cover, then followed by Mr. Becerra, and then there may be some additional limited cross-examination cleanup that Mr. Elajim may have. We did our best to coordinate our cross-examination to not have any duplication to the extent possible, so we're going to try to do this as efficiently as we can, like we've done with the other panels.
Excellent. And you estimate your total time to be?
I would say my time is probably only going to be about 10 to 15 minutes, and then I'll let the other council indicate their estimates.
Please, Mr. Cooper.
Dustin Cooper, an hour and a half.
Ryan Becerra, an hour and a half to 2 hours.
Okay, Mr. Elajim.
And Chair Duduk, David Elajim, I'll be doing some cleanup, probably not more than 15 to 20 minutes. But since I have a court appearance tomorrow in Southern California, if we run out of time this afternoon, I'd appreciate being able to do it next week.
Okay, we'll try to accommodate that, but I would encourage you to encourage Mr. Becerra to be more efficient.
I haven't even conducted any cross yet,
Well,
so hopefully I haven't been too inefficient today.
But 2 hours, we'll see, we'll see.
I will attempt to be as efficient as possible.
All right, thank you.
Okay, good afternoon again. This is Andrew Hitchings, and good afternoon, Mr. Sahlberg, Ms. Surgeon.
Good afternoon.
My questions are going to be, and Mr. Cook, I don't want to leave you out. Sorry about that. My questions are going to be focused mainly on Mr. Sahlberg's testimony, so I'd like to first refer to, well, first of all, actually, before I get to that, with regard to the cross-examination that ended right before the morning session, I did have some questions about whether, Mr. Sahlberg, you had discussed your testimony or the presentation of your testimony with any of the legal counsel from Westlands Water District or San Luis Delta Mendota Water Authority prior to the hearing today?
Yes.
Can you explain when those discussions occurred?
It took place over the period of 2 weeks. There was one session about 2 weeks ago and another one yesterday.
Okay, and who did you meet with from either Westlands or San Luis Delta Mendota or both?
I met with Mr. Williams, Ms. Ackroyd, Dan Hanlon, and John Rubin.
And did you meet with all 4 of those attorneys during both sessions?
I don't believe Mr. Rubin was present at the second one.
And what was generally discussed during those meetings or sessions?
We discussed the shortage provisions in the contract and the so-called Term 14 provision in the Folsom water right permits.
And did you exchange any written correspondence with counsel for either of those organizations as part of this face-to-face meeting sessions that you had?
I did not exchange any written correspondence.
Did you send any written correspondence to them?
I sent emails acknowledging receipt of documents from them.
And so that means you did also receive correspondence from them or documents from them as part of this meetings prior to your testimony? Okay, thank you. If we could change gears here and move on to DOI Exhibit 4, that's Mr. Sahlberg's written testimony. And in particular, if we could pull up page 8, and I'd like to focus on the second paragraph. And these questions are going to go to the Sacramento River settlement contracts. And in particular, if you could, I'd like to direct you to the third sentence in that, and it starts with the terms of the agreements vary slightly. Do you see that? And it's about 6 lines, 7 lines down in that paragraph.
Yeah.
And in that sentence, you state that base supply is an amount reclamation and the contractor agree satisfies their state-granted senior water rights, correct?
That's correct.
So I'm concerned about this characterization of the settlement contracts and particularly how base supply is characterized. So I have a few questions that are going to go into that. If we could refer to DOI 11, which is the Maxwell Irrigation District Form contract that was discussed earlier today. And you're familiar with this contract, is that correct?
Yes, excuse me.
And if we could look at, so in this contract itself, can you point to any provisions in that where the parties have agreed that base supply quantities satisfy the contractor's senior water rates?
It might be in the explanatory recitals.
As you're sitting here today, can you think of anything specific in the explanatory recitals that uses that term that you did, that it satisfies the senior water rates?
No, I can't.
And if I could direct your attention to page 4, it's actually page 4 of the contract itself. It might be PDF 6. And in particular, Article 1D. In describing and defining contract total there, that period that's covered under the contract and the agreement on diversion quantities under the contract total is from April 1st to October 31st. Is that correct?
That's correct.
And if we could move to page 19 of that same contract, and it's the contract a page number, which might be PDF 21, I think. And in looking at Article 9(1)A, when it's referring to the agreement on water quantities, is that correct?
You mean Article 9A1?
I'm sorry, 9A1, thank you.
I'm sorry, what was your question again?
This term addresses the agreement between the parties on water quantities, is that correct?
That's correct.
And again, this covers, if you look at line 425, it indicates that the contract covers the period April 1st to October 31st, correct?
That's correct.
And if we could move to Exhibit A of the contract, I think that's right after page 36. Maybe 2 more pages down. Next page. And so this schedule of diversions under the contract, this also just covers an agreement with regard to the period April through October. Is that correct?
That's correct.
So the settlement contracts, they include agreements with regard to diversions only during the period April through October, correct?
Correct.
And so they do not limit the settlement contractor's diversions under their water rights outside that period. Isn't that correct?
That's correct.
And so some of those settlement contractors may have water rights that are outside that period that are not covered by, or otherwise, using your term, satisfied by the contract. Is that correct?
That's correct.
And if we could move to back to Article 9 on page 19. And it's contract page 19. And again, this is the agreement on quantities of water. In reading this, Article 9A1, it says, during the term of this settlement contract and any renewals thereof, it shall constitute full agreement between the United States and the contractor as to the quantities of water. Is that correct?
Yes, that's what it says.
And then if we move to Article 9D on page 21, 2 more pages down. The first sentence of paragraph D there at line 467, if the contracts are not renewed or they're otherwise terminated, the parties have agreed that the rights of the parties to divert and use water shall exist as though the settlement contracts had never been entered into. Is that correct?
I believe it says have not been entered into, but yes, that's correct.
Okay, thank you. So given these provisions that indicate that the term of the contract or the period of time each year covered by the contract is only April through October, and the fact that the agreement on the quantities of water to be diverted are only during the term of the contract or any renewals thereof, the parties have not, in fact, agreed that the contracts satisfy their senior water rights. Isn't that correct?
Can you go back to 9A1, please?
Were you confused with my question, or do you need to review this to answer that question?
The contract, well, according to 9A1, it's an agreement on the quantities of water for April through October, but not for the whole year.
So your statement in your testimony on page 8 says that they agree, Reclamation and the contractor agree that the base supply satisfies their senior water rights. Isn't that correct?
That's what it says, yes.
But the contract itself only covers April through October and only covers during the period that the contract is actually being performed and in place. Isn't that correct?
That's correct.
So isn't it also correct then that it can't necessarily satisfy all of the settlement contractors' senior water rights, using your terminology?
I'm sorry. Can you rephrase that? You said it. I don't know what you meant by it.
Your testimony is that the parties have agreed that the base supply quantities agreed to satisfy their senior water rights. Isn't that correct?
Yes.
But the contract only covers a defined period and only covers when the contract is in place.
That's
so
correct.
That agreement is limited to what they agree to divert while the contract is in place, correct?
That's correct.
And only that. Isn't that correct?
That's correct.
Okay, during your cross-examination by San Luis Delta Mendota with regard to this exhibit, there was some discussions with regard to Article 3I. If we could go to that provision.
Do you have a page number, Mr. Hutchins?
Yes, excuse me, sorry. It's on contract page 12. During that cross-examination by you, do you recall that being characterized during the questioning as a so-called shortage provision?
Yes.
And that provision is really a limitation on liability provision, not a shortage provision. Isn't that correct?
I suppose you could characterize it that way.
Are there more specific provisions in the contract that deal with critical year cutbacks and constraints on availability of water?
Are you talking about Shasta critical years?
I'm talking about whether there's other provisions in the contract that more directly address when shortages are imposed under the contracts.
Yes.
And with regard to Article 3I, that only applies to project water quantities under the contract, not base supply quantities. Is that correct?
That's correct.
Okay, I think that's all I have. Thank you very much for your testimony.
Thank you, Mr. Hitchens. Mr. Cooper?
Good afternoon, hearing officers, witnesses. My name's Dustin Cooper. I represent 9 protesting parties as part of the Sacramento Valley Water Users Group. Ms. Sargent, my questions will be directly, mostly to you. They concern hearing officers the facts Ms. Sargent is relying upon in support of her statements that there is no injury to other legal users of water resulting from the WaterFix. I will also ask questions concerning Ms. Sargent's description and understanding of the diversion agreements between the entities on the Feather River and the state of California. I have some questions about DWR's policies and Ms. Sargent's training related to assessing injury to other legal users of water. And as I spoke before, I anticipate my questions taking approximately 1.5 hours. Ms. Sargent, if I've handed out before you a stack of documents, the first is DWR 53, which I've identified as MLF 2 because I have some highlights on it to ease in locating where I'm going to ask you questions. So if you can turn to page 2 of that document. Lines 12 through 15, your written testimony says, I evaluate petitions for change submitted to the State Water Board by other water users for potential impacts to SWP water rights and file protests and participate in State Water Board proceedings as necessary related to changes that may affect DWR's water rights. Do you see where your written testimony says that?
I do.
When you use the phrase potential impacts to the State Water Project water rights, are you referring to potential injury to the State Water Project water rights?
I am.
So can we use those two words interchangeably, potential impacts and potential injury?
Probably.
Does DWR have a policy on how it assesses whether third-party petitions for change may injure its State Water Project water rights?
I don't know. We don't have a policy. I review petitions to determine if during Term 91 conditions water might be diverted that would not otherwise be diverted, and it would result in less water in the system.
So if DWR does not have a policy to help you assess whether any third-party petition may impact its State Water Project water rights, describe for me how you were trained to assess whether there may be injury.
Well, as I've been working with State Water Project water rights since the 1991 Drought Water Bank, I came to DWR at the end of my master's program, in which I took a course at the UC Davis School of Law in water law, as well as a course at the UC Davis in water law. I've attended a number of water rights conferences throughout the years. I used to attend an annual conference to try to keep up on issues related to water rights. My focus in my master's program was on water resources management, and I felt that water rights were an important aspect of trying to determine whether or not something would affect potentially DWR's water rights.
In your experience,
Hold on, Mr. Cooper, before you continue. Ms. Surgeon, if you could move the microphone closer to you. I can barely hear you, so others might
Sorry.
have trouble.
Is that better?
Much better, thank you.
in your experience, based on your work with DWR, would DWR conduct modeling of a proposed change to determine if there's a potential injury to its water rights?
It would depend on the change proposed.
In your experience, have you in fact in the past done modeling of a third-party proposed change?
I don't do any modeling. I would rely on any modeling done by DWR's modeling staff.
But DWR has, at least that you're aware of?
Trying to think of change petitions. I believe there, yes, I can think of at least the Contra Costa Los Vaqueros change.
Would, in that particular instance or any other that you're familiar with, would DWR use the same modeling that has been used in this proceeding?
I'm not a modeler. I would not know what type of modeling was done.
Then I think I know the answer to this question. Would you know the version of the modeling that DWR used in these other proceedings?
I would not.
Okay. Do you know if DWR would model project operations without the change and then model project operations with the proposed third-party change?
I can't speak specifically to any modeling questions.
Were you directly involved in the Los Vaqueros change petition that you mentioned earlier?
Just indirectly.
In your training, have you assessed whether there's a minimum threshold of potential injury before DWR may decide to file a protest to a third-party change petition?
I have not. We evaluate each petition on its own.
To your knowledge, will DWR protest petitions for change by third parties if there's a potential for any injury to its water rights?
We decide which petitions, whether or not to protest a petition based on the individual petitions and whether or not it's in a basin that is tributary to the area that the State Water Project operates. And if the petitioner has agreed to include petitions that would say include Term 91 or something like that would protect the department, we would not necessarily protest.
So I'm trying to ask questions directed to the threshold. What, based on your training, your experience, what's the minimum threshold that you need to see before you would recommend DWR protest a third-party change petition?
And I think I answered that we don't have necessarily a threshold. Each petition is evaluated on its own.
Is it fair to say generally that the face value of DWR's State Water Project water rights amount to millions of acre feet per year?
That would be true.
In your opinion, and based on your training and experience, would DWR protest a third-party change petition if the requested change resulted in the possible unavailability of 1 acre-foot available to DWR under its permits to the State Water Project?
Objection asked and answered. Witnesses indicated they address each transfer on itself without a threshold.
I would agree. Mr. Cooper, please move on.
Ms. Sergeant, if we could just scroll up to same page of MLF2, which is your highlighted written testimony, lines 1 and 2, you're reciting kind of your work experience, and that you have extensive work evaluating water transfer proposals and requests to convey transfer water through SWP facilities. Do you see where your testimony says that?
I do.
Now, you and I have worked together extensively on water transfer proposals, so I'm familiar with the process, but my question is just to inform the hearing officers in the audience about your procedure when you receive a transfer proposal that the proponents wish to use state water project facilities. And I'm specifically referring to Water Code Section 1810D with a particular focus on the no injury evaluation as part of that code section. Can you explain to us your understanding of that?
My understanding of Water Code Section 1810 D. When we, Water Code Section 1810 says that if there is capacity available in public entities' facilities, that we make that capacity available to to the transfer, the potential transfer E, if the transfer can be made without injuring other legal users of water, without unreasonably impacting, say, the environment, or without unreasonably impacting the county in which the water is developed.
When you're assessing water transfer proposals and assessing third-party petitions for change, is there any difference in your training or your experience in what you believe may constitute an injury to DWR's State Water Project water rights?
That depends on the petition. Petition can be made for transfer purposes, to appropriate to make a new appropriation, to export water. It depends on what the petitioner is requesting and where that petitioner is located.
Mr. Baker, if you would pull up the document I've identified as MLF4. Ms. Sargent, you've already authenticated this with Mr. O'Loughlin's question, but just again, you are familiar with this document, correct?
Yes, I am.
Mr. Baker, if you would scroll to the next page where the highlighted text is. That reads, this is Appendix A of the Water Transfer White Paper, and it reads, the highlighted text reads, when the projects contract to convey transferred water through their facilities or otherwise weigh in on proposed transfers, they must be sure that the water supply to which their project contractors are legally entitled is not unlawfully diminished by the transfer. If it is diminished, it is effectively an involuntary and uncompensated transfer of someone else's water and constitutes legal injury. Do you see that text?
I do.
Do you see the phrase unlawfully diminished?
I do.
What is your understanding of that phrase?
I did not, I just want to clarify that I did not write this particular section. One of the attorneys in our Office of Chief Counsel prepared that section.
Okay, thank you. What is your understanding of the phrase unlawfully diminished?
Well, I'm not prepared to make a legal determination of what is lawfully or unlawfully. I can explain how we try to ensure that someone else's water is not included in a transfer.
Well, I'm trying to understand. Your testimony is that you have extensive experience evaluating water transfer proposals, and correct. I believe that includes an assessment under 1810D of whether that transfer injures any third party, including DWR.
That's correct. And if your question to me is how do we assess whether or not that transfer might injure another legal user of water, I can address that.
Yes.
Okay. With respect to transfers, we look at the method being proposed to make water available. Each method being proposed has the potential to change the downstream supply in a different way. So what we try to assure is that the water supply Downstream will not see a reduction due to what we call, say, a paper water transfer. Someone has the right to divert 10,000 acre feet of water. That doesn't mean that they consume 10,000 acre feet of water. A portion of that would return to the system as return flow. So we try to look at the net difference, the net amount of water that would be made available by any particular proposal, so that we are not including what would otherwise return to the system in the amount of water that we agree to convey through the State Water Project.
You mentioned that one of the things DWR is trying to prevent is a reduction in downstream flow.
That's correct.
In your opinion, is any reduction in downstream flow an injury to DWR's water rights?
Objection asked and answered. This again goes to the threshold of injury that we talked about 10 minutes ago.
Let's answer it one more time for the record.
We don't assess a threshold, and whether or not it's 1 acre foot or 10 acre foot, we use the same methodology to assess every transfer.
Do you attempt to avoid all downstream reduction in flows?
What we attempt to do is use the best available information we have to us to estimate the net amount of water that would be made available by any transfer, and to limit the amount that we would convey to that.
Okay, Mr. Baker, if we can return to MLF 2, and Ms. Surgent, this again is DWR 53 with highlights. It's your testimony with highlights. Mm-hmm. Page 3, footnote 2, which reads, in my testimony, I use terms of art that are commonly used in water rights related activities, such as injury to other legal users of water or beneficial use. This terminology is used in relation to my analysis of the facts and not intended to express legal conclusions. Do you see where your testimony says that?
I do.
For purposes of my remaining questions for you today, when I ask questions about injury to other legal users of water, I'm going to adopt the same caveat that you have. I'm just asking you for facts, not asking you to offer a legal conclusion. Is that okay?
Okay.
So as I read your testimony, there's 10 or so locations where you say either verbatim or in effect that the California WaterFix will not injure other legal users of water. Do you generally recall that testimony?
I recall that in my testimony I do make reference to the project will not injure any other legal user of water. I don't know how many times I mention it.
When you offer that testimony, are you using the same standards that DWR uses in the context of third-party petitions for change and water transfer proposals that utilize state water project facilities?
I use the same basic principles with respect to the state water project. In most cases, I'm referring to how we will maintain certain specific standards that have been determined by the Water Board to be protective of water rights.
So based on this explanation in footnote 2 of your written testimony, your testimony is that there are no facts that you are aware of that would lead you to the opinion that the California WaterFix injures any other legal user of water?
My testimony is that I've reviewed the information prepared, and based on my review of that, I don't see anything that would lead me to conclude that there would be an injury to another legal user of water.
So if there were facts presented to you that showed a potential for injury, that would potentially change your general opinion that the California WaterFix will not injure other legal users of water. Is that correct?
I'm not going to say that something that would be presented would change my opinion. I'd have to see what that was and how it was prepared and be able to understand what went into it.
The question was just that it would potentially change your opinion.
I'm going to object. It's asked and answered under the questions that Tim O'Laughlin asked at the beginning of the day.
Please, I appreciate where you're going with this. And I appreciate it puts the witness in a difficult position. But as an engineer, as a technical person, when offering data, do you approach data analysis with an open mind and reach conclusions based on that analysis?
Yes.
And if data, when new data is provided, should your analysis lead to different conclusions, you would revise accordingly?
Absolutely. We would consider the information before us, the validity of it, have it analyzed, and certainly.
Thank you. I think we've put that one to rest. Move on, Mr.
Okay.
Cooper.
Thank you. Okay, Ms. Sergeant, if I could direct your attention to the document identified as MLF2, that's your, again, your written testimony, page 3, lines 22 through page 4, lines 3, which, in which you testify, my testimony builds on the information of other testimony in part 1 to provide additional information to the State Water Board to support a decision that, within the framework of DWR's water rights, regulations, and contracts, the CWF can be constructed and operated without injuring other legal users of water. This other testimony includes Mr. Lehi's testimony describing decisions on the timing and quantities of water deliveries based on real-time hydrologic and hydrodynamic information, and modeling testimony by Dr. Nader Tarani and Mr. Munavar. Do you see where your written testimony says that?
I do.
Is it fair to say that your conclusion that there are no facts leading you to believe that the California WaterFix causes injury to other legal users of water is based in part on Mr. Lehi's description of how the California WaterFix would be operated in real time?
Based in part.
Are you aware of DWR's and Reclamation's factual stipulation that they have not proposed any permit terms or conditions in this proceeding?
Yes, I am.
Are you aware of Mr. Lehi's testimony that there are no currently proposed permit terms or conditions that would require the California WaterFix to be operated in real time as described by Mr. Lehi?
I remember a general discussion of that. I can't repeat verbatim what Mr. Lehi said, but
You're generally aware of it? Okay. So the question to you then is, in the absence of a firm commitment from DWR to operate the California WaterFix as described by Mr. Lehi, how can you so definitively state that there are no facts that you are aware of that the California WaterFix may injure other legal users of water?
Objection. That mischaracterizes Mr. Lehi's testimony. It's taking it entirely out of context.
I'll ask you to try to clarify your question.
Well, I thought Mr. Lehi was pretty clear. When I was cross-examining him, I asked him, had him go through how he would propose operating the California WaterFix, and he gave a very thorough description of that. And then I asked if DWR had proposed any permit terms or conditions that would require operations in the manner he described, and he said no. I think I've fairly described Mr. Lehi's testimony. My question to Ms. Sergeant is, given that, which you can disagree with me, that's Mr. Lehi's testimony, but given my understanding of that, how can you so definitively say that the California WaterFix, there's no facts that you're aware of that would result in potential injury to third parties resulting from the California WaterFix?
And the
Mr. Berliner?
And the basis for my objection is that Mr. Lehi's testimony explains, first of all, the difference between modeling and real-time operations and how he operates in real time to avoid injury. So it's
within the boundaries.
Exactly. So within the context of WaterFix, based on how they operate today and how they would operate under the WaterFix criteria, to my mind, Mr. Lehi made it very clear that while modeling might show an impact at a given time, for instance, let's say to water quality in the Delta, that they would take into account current barometric pressure, tidal impacts, et cetera, and make real-time adjustments that could never be shown in the modeling because the modeling is not capable of doing real-time adjustments to the project. So in that way, he put forth the proposition that in order to avoid an injury, whether it's quality or quantity, he would make those real-time adjustments.
Thank you, Mr. Bellina. That was my understanding of his testimony as well. So I sustain the objection and will give you another chance if you want to rephrase your question.
Is there any operational scenario, Ms. Sargent, that you can envision where there may be facts giving rise to a potential injury to third parties resulting from the California WaterFix?
I can't envision that as I sit here today. I think Mr. Lehi spent some extensive amount of time describing how under current operational conditions, we frequently have surplus capacity at the existing export facilities. And therefore, if the project was inclined to operate such that it would jeopardize meeting its settlement agreements or its water quality requirements, it would have an opportunity to do that now. And we do not operate that way. We take our obligations very seriously. This is adding additional flexibility, but the primary function, as Mr. Lehi indicated, was going to be to attempt to capture some of those surplus flows in the drier year types when it might be a concern to draw reservoir levels down further than what we do now. If we were going to operate that way, we could already operate that way now because during those drier years is when we have the export capacity at the pumps. Export capacity at the pumps. So I cannot envision a scenario where the California WaterFix would result in an injury to other legal users of water. As Mr. Lehi indicated, it adds flexibility at the time where reservoir levels are a concern. He would add flexibility, but he didn't envision sending more water during those periods.
Okay, if we can change to page 11 of MLF2. Lines 10 through 11, excuse me, 10 through 13. This is where your written testimony says, although there may be changes in SWP/CVP storage levels or releases, see Exhibit DWR 71, Section VC, this would not injure other legal users because it is my understanding that such water users do not have a right to stored water releases from the SWP/CVP. Do you see where your written testimony says that?
I do.
And if I recall, Mr. O'Loughlin spent quite a bit of time on this, so I would hope that you are exploring a different aspect.
I am, yes. What legal users are you referring to?
Any other diverter outside the two projects under their individual water rights?
Would that include Feather River entities that hold diversion agreements with the state of California?
The department has contractual obligations to those settlement agreements, but all of the water diverted under those permits, say at Lake Oroville, are diverted under DWR's water rights.
Let's take one question at a time. I think we'll get to that. But I'm just trying to get you to identify when you identify these other legal users, I'm trying to understand who's the universe of other legal users you're referring to?
I believe I said any user or diverter other than the State Water Project for our water rights purposes.
So then that would include the entities on the Feather River with diversion agreements?
Yes.
If it was in fact presented to you that some in-basin water users are entitled to stored water releases, would you then conclude that there is the potential for injury to other legal users resulting from the California WaterFix?
Again, all of the water stored at Lake Oroville is stored under DWR's water rights. Other water users, for example, Western Canal Water District, has agreements with Pacific or PG&E to release stored water for their purposes. That stored water is released from upstream and delivered to Western Canal. That is distinct from saying that Western Canal would now have a right to, a water right to water stored in Lake Oroville. That's water stored under a separate water right that is delivered by that water right holder and conveyed by the department.
So you mentioned Western Canal Water District. They are one of the entities holding a diversion agreement with the state of California. Is that correct?
We do have a settlement agreement with Western Canal Water District. Yes, that's correct.
I'm going to refer to those agencies as the Feather River contractors for shorthand. Is that okay with you?
As long as, if we get into particulars, we identify which, because they have different provisions in their agreements.
Okay, fair enough. Are you generally aware of the terms of the, I believe there's 6 agreements with the Feather River contractors?
Generally.
In your opinion, based on your understanding of those agreements, would the state be obligated to draft storage if necessary to provide the quantities of water set forth in those diversion agreements?
Yes, we do that. There are times when some of the water provided to those contractors comes from Oroville storage.
So then in the hearing officers considering your testimony here at page 11, lines 10 through 13, the hearing officer should understand that the Feather River contractors are entitled to storage releases from Lake Oroville if necessary to deliver the quantities of water set forth in those agreements. Would you agree?
There are times, as I said, when a component of the water that we release to the diverters on the Feather River does come from Lake Oroville storage. But that water, again, just to clarify, is stored under DWR's water rights.
We can go back, Mr. Baker, to page 10 of MLF2. I'm sorry, this is not highlighted. It's lines 26 through 28, which reads, DWR testimony and supporting documentation provide evidence for the State Water Board to determine that the changes proposed in the petition can be approved without injuring other legal users of water. Do you see that, Ms. Sergeant?
I do.
What facts specifically are you drawing upon in this other DWR testimony and supporting documentation to support your opinion that the California WaterFix can be approved without injuring other legal users of water?
I reviewed the information provided by Mr. Munivar that looked at the reservoir levels, the results of the modeling that showed potential changes in reservoir levels, with specifically considering the upstream requirements of the settlement agreements. Those graphs showed essentially no change in end of September storage, and which led me to conclude that there would be no change in DWR's ability to meet the obligations of the settlement contracts. And with respect to other water users, say in the Delta, I looked at Dr. Nader Tehrani's results from the DSM-2 modeling, as well as looking at his results for the water levels. And then I looked at Mr. Lehi's testimony with respect to current operations.
And proposed operations as well?
And proposed operations, yes, that's correct.
Anything else that you reviewed or are relying upon?
I also have looked at some of the information. I had the models provide me with some more specific information related to compliance locations of specific individual contracts that were within the Delta.
Are those documents part of the record in this proceeding, or were these separate documents that you requested and reviewed?
They are the modeling results. We did not present specific graphics at those locations, but they are in the modeling results.
Okay. Have you monitored the presentation of direct testimony and cross-examination of the prior witness panels?
For the most part.
Have you heard any new or different facts since the submittal of your written testimony that alters your opinion that the California WaterFix will not injure any other legal users of water?
No, I have not.
How many years have you been part of the team at DWR assessing what was then known as BDCP, now known as the California WaterFix?
I'm not a part of the BDCP team. My involvement has been related to this change petition.
So you first became involved when the change petition was filed?
That's correct. Well, in preparation of the change petition, yes.
And was that just a matter of months before it was submitted, or years?
I believe it was at least a year. I can't say if it was longer than that.
Okay.
I'm sorry, I have to correct that. I was also involved in development of some of the information for the BDCP documents with respect to water transfers. But with respect to water rights, my involvement started with this petition.
Okay. At any point prior to your signature of your testimony, which I believe was May 31st of this year, were you concerned at any time that the California WaterFix may injure other lawful users of water?
Well, as I said, I was not involved in the petition before that, but based on my work with DWR, we operate to meet the objectives in the Delta and in basin needs, so I would not have a reason to be concerned about something that they were proposing.
At page 23 of your testimony, which is DWR 53, you described the California WaterFix settlement agreement with Contra Costa Water District that was executed on March 24th, 2016. Do you recall that testimony?
I do.
Prior to execution of that agreement, was it your opinion that the California WaterFix resulted in injury to Contra Costa Water District?
My opinion hasn't changed. I don't think the California WaterFix facilities results in an impact or injury to any legal user.
So then why did DWR, at least to the extent of your understanding, why did DWR enter into that settlement agreement with Contra Costa Water District?
I was not involved in the negotiations, but it is my understanding that the settlement agreement was a much broader agreement. It was not related just specifically to water or changes in water quality at that location. It's a settlement of potential CEQA issues. DWR entered into it without admitting any liability associated with any particular injury, but it was to cover a much broader range of issues. But I was not involved in those negotiations.
Okay. So if that agreement had not been executed, what I'm hearing you say is you would still have the same opinion that you have today, that there are no facts that you're aware of giving rise to potential injury resulting from the California WaterFix.
That's correct.
Okay. Okay, returning to MLF2, Ms. Sargent, page 11, lines 24 through 26. Which reads, the modeling demonstrates that changes in carryover storage levels from the 4 CWF scenarios would be higher or similar to storage levels in the NAA. This information demonstrates a continued ability to meet contractual obligations. Do you see where your testimony says that?
I do.
Do you recall Mr. Lehi and other witnesses explaining that one limitation in modeling is that it does not necessarily capture all the nuances of real-time operations?
Yes, I do.
If modeling could more closely reflect real-time operations, would you consider that a good improvement?
I'm not a modeler. I don't know that I need to opine on any changes that might be made to the model.
So do you just don't have an opinion on whether that'd be a good improvement?
I don't have an opinion on what improvements might be made and what effect they might have.
Would you consider improved modeling to be a better tool to assess whether the California WaterFix may injure other legal users of water?
Again, I believe that the modeling that was done with the best available tools to DWR's modelers, and that's what I base my conclusions on.
So if there was improved modeling that demonstrated a reduction in carryover storage in the upstream State Water Project and CVP reservoirs, would that be a fact that would change your opinion on whether the California WaterFix injures other legal users of water?
It would not. As I indicated before, if another party presented a modeling that showed that, to me it would be inconsistent with how the project currently operates. In my work with transfers, typically if the allocation is at or below 50% to our State Water Project contractors, that means that there will be some conveyance capacity at banks during those years. And so, again, we are not necessarily export limited during the average or below normal years. So I don't see, it would be inconsistent with my experience in how the project has been operated to date. We already have conveyance capacity in excess of what we can use to the level that we think is reasonable to protect the ability to meet our obligations in the following year.
So back to the scenario I'm presenting where there is an improved model that more closely reflects real-time operations. And if that improved model demonstrated a decrease in the reliability of the upstream reservoirs, in the ability to comply with the terms of the various diversion agreements and settlement agreements, would that be a fact that would change your opinion on whether the California WaterFix injures other legal users of water?
I'm going to stop here because even I can answer that in terms of what she's going to say, and what she has said is the scenario, in her opinion, the scenario you outline, that modeling scenario, in her opinion, is not realistic and would not reflect the operational parameters that she understands the project will be operating under. So I don't think you're going to get more from her than what you've gotten to date. So I would encourage you to move on.
Okay, I will. Okay, if we can, it's actually beginning on the same page of your written testimony. Scroll down, Mr. Baker. There we go. Starting at the end of page 11, line 27. Your testimony reads, also as stated in Mr. Munivar's testimony, water deliveries to CVP and SWP contractors, including settlement contractors exchange contractors, refuge level 2, and Feather River service area contractors are provided at the same level as the NAA under all CWF scenarios. Then there's a citation to Exhibit DWR 71. Your testimony continues. This modeling demonstrates that the CWF operations would result in insignificant changes to water deliveries to these contractors and refuges, and thus would not cause injury to legal users of water. Do you see where your testimony says that?
I do.
Returning to your experience on behalf of DWR reviewing water transfers proposals that use state water project facilities and third-party petitions for change, would DWR be concerned about either a transfer or a third-party change petition that resulted in insignificant changes to its water deliveries?
I believe you're conflating two completely different things. The statement here refers to the fact that the modeling shows insignificant changes, therefore, which likely could be modeling artifacts, and all I'm referring to is that this demonstrates that it won't affect our ability to meet our contractual obligations. It's very different than your question posed as far as how we analyze water transfers. In this case, we expect to be able to fully comply with those settlement agreements and deliver all the water to which those contractors are entitled. We're not proposing to move water outside our place of use to any other diverter, and so I'm just not clear as to what you're trying to get at with respect to transfer provision. We intend to fully comply with these settlement agreements and provide all the water to which those settlement contractors are entitled.
Well, what I'm trying to get at is if the roles were switched and DWR was sitting in the protestant's seat, would you let slide insignificant changes using your terminology? Would you yourself be concerned about that?
It's the modeling showed insignificant changes. Therefore, given the operational flexibility that we have at Lake Oroville, there will be no change in the ability to deliver the full entitlement amounts to the contractors. The reference to insignificant changes just means that I looked at the modeling results. Nothing in those modeling results indicated that it would impair our ability to meet those contractual obligations. The modeling results don't say that we will now deliver a different quantity of water to those settlement contractors. It indicates that we will have the same ability to deliver water to the contractors as we have done historically.
Switching topics slightly, are you aware of the State Water Board standard permit term 91?
Yes, I am.
Do you consider water right holders with term 91 to be legal users of water?
I do.
If the California WaterFix resulted in term 91 being invoked more frequently, would that be a fact that would impact your opinion on whether the California WaterFix would injure other legal users of water?
I didn't see anything in the information developed as part of the WaterFix that would indicate to me term 91 would be invoked any more frequently as a result of the project being proposed by the department's proposed project.
Right. My question is, if the project did result in term 91 being invoked more frequently, would that be a fact that would lead you to conclude that there's an injury?
It would depend on what was causing term 91 to be invoked more frequently and whether or not the board determined that the obligation for that was an in-basin obligation or an obligation of the projects. And When I look at the information that's available, that has been developed for the water project, the department is proposing a project that is between H3 and H4. H3 contains the requirements as the outflow requirements and the conditions in D1641. There are some additional outflow objectives in H4. However, those objectives occur in the March through May time period when Term 91 is not invoked. They are also applicable in years in which the end of May storage is anticipated to be at least 2 million acre feet or above. So those are not the drier year types. And based on my experience and discussions with our operations staff, the controlling objectives leading up to the period when Term 91 is invoked are typically outflow requirements. And so those outflow requirements are based on inflow to the delta. Nothing in the California WaterFix will change inflow to the delta. And so therefore I don't see anything that could result in, that would result from the project being proposed by the department, an earlier implementation of Term 91. If the Water Board elects to impose an outflow requirement that would continue into the time period as it gets drier, that is above what the department is proposing, I don't have an opinion as to whether or not that would be, could result in an injury to any other legal user.
Is it fair to say if that scenario just played out, that you would need to reassess whether there's potential injury?
If that scenario played out?
The scenario you just described where there's a water board requirement for delta outflow.
That would be something for the Water Board to determine the who would be responsible for that. If it's determined to be an in-basin use, then I think it would be appropriate that Term 91 be implemented earlier to protect the inflow to the delta if that's what the board determines is necessary to meet objectives.
Okay. Mr. Baker, if you wouldn't mind going to DWR 3, page 8. Now, Ms. Sargent, this is your PowerPoint presentation from this morning. Do you see the bullet that says CWF specific requirements will be adopted?
I do.
What requirements are you referring to?
Those requirements would include any bypass requirements or sweeping velocity requirements, anything, I'm sorry, sweeping velocity requirements, any specific requirements related to operation of the 3 intakes or operation of the State Water Project that isn't contained in any State Water Board order.
Are the CWF specific requirements that may be adopted limited to the options you just described?
No, those are, I believe, will come out of this proceeding.
Is it possible that additional or unforeseen requirements could be placed on the California WaterFix?
I can't speculate as to what the Water Board is going to include in its order.
So it's possible there may be something that you're not anticipating today.
I guess it's possible.
Given that you do not presently know the full range of potential requirements that will be adopted, how can you definitively state that there are no facts that you are aware of that demonstrate injury to other legal users of water?
Oh, I think I've said a number of times that DWR it intends to continue to meet the obligations in its permits. D1641 requirements and the other requirements. I don't foresee a water board term that would impact other legal users of water.
Are you aware of a requirement in this proceeding to adopt an appropriate delta flow criteria? Before you answer, I realize, Madam Hearing Officers, that this is a Part 2 issue, but so I'll have very limited questions.
I'm aware that that's one of the elements considered in this proceeding.
Informing your conclusion today that you are not aware of any facts giving rise to potential injury to other legal users of water, have you considered an appropriate delta flow criteria?
As I think has been discussed numerous times, the project being proposed by the department is a project between H3 and H4 that does contain specific outflow. The department has analyzed a much broader range at the request of the board.
Is it possible your conclusion today could change depending on what ultimately is adopted as the appropriate delta flow criteria?
I don't believe so.
And why is that?
As I think I already went through, the project, the department is proposing a project that is between H3 and H4. When I reviewed the information developed for the proposed project, I did not see anything in either the criteria or the proposed operations that would lead me to believe that they would result in any injury to any other legal user of water. If the board elected to impose a flow objective that was greater than that, it would depend on the board's determination if that flow component in excess of what the department was proposing would be considered part of an in-basin obligation or something that was imposed in-basin obligation as opposed to something that was specific to the potential impacts associated with the California WaterFix. That would be something for the board to evaluate.
So then is it fair to say that your conclusion today is based on the proposal in the range of H3 to H4?
Well, I don't see anything in the what we've presented, H3 to H4, that would result in an injury to other legal users of water. I think we can say the same about the entire range of what was analyzed.
Do you recall my questioning of Mr. Lehi concerning the possibility of future temporary urgency change petitions, or TUCPs, affecting the operation of the State Water Project and California WaterFix?
I recall that there was a considerable amount of discussion by a number of people on the issue of TUCPs.
Do you recall my questions to Mr. Lehi concerning potential future possible conditions of approval imposed by the State Water Resource Control Board?
I don't.
Mr. Cooper, perhaps I could urge you to move along and just ask Ms. Sargent the question you specifically want to ask her without having necessary to refer back to previous testimony.
Okay. Do you understand, Ms. Sargent, that the State Water Board maintains that conditions of approval on a potential future TUCP, that those conditions are not subject to a no injury assessment?
Could you restate that?
Sure. Are you aware that the State Water Board takes the position that conditions of approval on a future TUCP are not subject to a no injury assessment?
I'm going to object as to relevance. I'm not sure what the standards that the board holds itself to have any relevance as to the standards that Ms. Sargent has used in evaluating this project.
I was a bit unclear about the question too, Mr. Cooper. Perhaps you could further clarify.
Well, I think Mr. Lehi and other witnesses have explained that TUCPs are on the suite of options governing future operations of the California WaterFix. And the TUCP process itself has a no injury analysis, but the Water Board, and I have an order from the Water Board that sets this out, has taken the position, at least in the past, that any conditions of approval set forth in that TUCP are not subject to a no injury analysis.
And your question to Ms. Sargent is?
Is it possible that future TUCPs with conditions of approval addressing the operations of the California WaterFix may injure legal users of water?
Objection is to vague.
Well, and I wouldn't speculate as to what any terms or conditions the Water Board might place on a future TUCP. The Water Board, in its order, goes through its reasoning as to why it had, I mean, it evaluates every proposal and it goes through the reasoning as to why it believes this can be done without injuring other legal users of water. I'm not sure what additional information you're looking for.
Okay, well, let's move on to a different topic. If we can go back, Mr. Baker, to MLF2, page 17. It's the bottom of 17, carrying on to page 18.
And as Mr. Baker is doing that, I noticed you're about to run out of your first 60 minutes anyway. You've gone through quite a vast topic. What additional areas do you have?
I only have one. I maybe have 10, 15 minutes.
That's what I thought. All right, let's go ahead and give him another 10 minutes, and then we'll take a break when he's done.
Thank you. Okay, your testimony at page 17, beginning at line 25, reads, the settlement agreements, which is referring to the agreements the state of California has with the Feather River contractors, contain no entitlement to SWP water stored in Orville, storage of local water, or end-of-season storage in Lake Orville. Water stored in Lake Orville is stored exclusively under DWR's water rights. The contractual entitlements contained in the settlement agreements are independent of Lake Orville storage, and DWR has sole discretion over, Mr. Baker, scroll down just a little bit. Thank you. DWR has sole discretion over operational decisions related to reservoir operations, including water levels and storage releases. Do you see where your written testimony says that?
I do.
Now, this portion of your testimony caused significant concern to the Feather River contractors. Are you generally aware of their concern?
I am, generally.
The Sacramento Valley Water Users Group, of which the Feather River contractors are members, submitted evidentiary objections on the basis that the agreement should speak for themselves, not your testimony. Are you aware that they submitted that evidentiary objection?
I may have read an objection. I can't say that I remember what was in it.
Okay. Mr. Baker, if you would please pull up the document I identified as MLF 5. Now, Ms. Sargent, this is a letter from the Feather River contractors, and you see their letterheads there. And just a second. It's dated July 15th, 2016. Have you seen this document before?
Yes, I have.
Have you read it?
Yes, I have.
To your knowledge, has there been any response to this letter by DWR?
That response is being handled by the Office of Chief Counsel, and I'm not aware of what the status of that is.
The letter requested a meeting between DWR and representatives of the Feather River contractors. Are you aware of any meeting occurring?
I am not, and I believe that you're aware of a number of conversations that have happened between DWR and yourself as to other discussions that are going on, and I'm not aware of any communications that have happened since that time.
To your knowledge, has DWR held internal meetings or engaged in discussions concerning this letter?
Yes, we have.
Can you tell me just approximately when those occurred and who was involved?
Well, there have been some discussions that I was not involved in, so I can't give you any information on those. We had at least one internal meeting in the week after we received the letter to discuss the issues contained in the letter.
Do you personally disagree with any statement in this letter?
I do.
Yeah, well, describe that for me.
If we can scroll down. Do you have a copy of the letter that I could see?
It should be in your packet before you.
Oh, okay. It's been quite some time since I read it, so if you'll give me an opportunity to read the letter. Well, in the last paragraph on page 2, you state that my testimony misstates the terms of the diversion agreement in that we have to operate Oroville to maintain or to meet the amount specified in the agreements, and therefore we do not have sole discretion to do what we want. I believe I said we have sole discretion over the operation of Lake Oroville, and that means that it is our operators who look at all of the obligations that we have at Lake Oroville, and it is our operators who make the decisions as to what water can be released when, and part of those considerations include the water supply necessary to meet the settlement agreements, the quantities contained in the settlement agreements. But the settlement agreements do not have, to my knowledge, any provisions that would indicate the settlement contractors can require that any specific end-of-season storage be met, or that Lake Oroville be operated in any particular way.
Okay, well, let's get into that. Mr. Baker, would you pull up the document I've identified as MLF3?
Excuse me, but would you like to go through other, there are a number of provisions in the letter that I do disagree with. Do you want to go through them, or do you want to just focus on?
Let's focus on this for the moment, and we can return. Mr. Baker, page 11, I'm not sure if it's PDF or, yep, that's it. Thank you. Ms. Sergeant, this is DWR 329 that I've highlighted. DWR 329 is a document you authenticated. It's the diversion agreement between the state of California and the joint water districts, the entities making up the joint water districts.
Yes, that's correct.
And I've highlighted section 2F of the agreement, which says state shall operate Oroville Dam and Lake Oroville and Thermalito Afterbay and related facilities and the Afterbay diversion structures to deliver the water provided for in Articles 2A, 2B, 2C, 2D, 2E, and Article 3 in accordance with the diversion schedules and notices to be given by the joint manager. Do you see where the agreement says that?
I do.
Are you aware that all the other diversion agreements contain similar clauses?
Each of the diversion agreements says that we shall operate Oroville in a manner that, so that we'll deliver the water under the agreements.
In your opinion, could DWR operate Lake Oroville and related facilities in a manner that negatively affects its ability to comply with the terms of the various diversion agreements?
We do not do that, no.
So then would you say that DWR's discretion in its operations of Lake Oroville and related facilities are constrained to those operations that are consistent with DWR's obligations under the various diversion agreements?
DWR's operations at Lake Oroville are constrained by a number of things, including our regulatory requirements and our contractual obligations. And our operators take all of that into account when they make decisions as to what amount of water can be released.
But it is their discretion when it comes to the operating of the projects,
That's
taking
correct.
into account all these agreements and requirements.
That's correct.
We've made that point.
Okay, well, that's all the questions I have.
Thank you. Before we take our 10-minute break, let me just, this is not only for Mr. Becerra who's coming up, but the other parties who will be conducting cross-examination. I've allowed Mr. O'Loughlin, Mr. Cooper, and others quite an extensive amount of time asking Ms. Sargent, and to a lesser degree, Mr. Sahlberg, questions that ask them to speculate about different outcomes. And as you can tell, they have been very reluctant to do so. I appreciate that some of you might wish to explore and restate all of that for the record for various legal purposes, but let me assure you that I would be very unwelcoming of that unless it adds value to this board's understanding in making the decision that is before us. So when you conduct your cross-examination, please keep in mind that these witnesses, in particular Ms. Sargent, has repeatedly said that they're not comfortable speculating on potential improvements in modelings that might result in a different outcome. So please consider that as you conduct your upcoming cross-examination. With that, we will take a 10-minute break and we will resume at 2:40. It's 2:40. Welcome back. And we will now turn cross-examination by Group 7 over to Mr. Becerra.
Thank you very much. Good afternoon. My name is Ryan Becerra. I represent the cities of Folsom and Roseville, Sacramento Suburban Water District, and San Juan Water District. Chair Dodek, the subjects I plan to cover, I plan to cover briefly the communications that Reclamation had with Westlands and San Luis and Delta Mendota Water Authority. I'm sorry, I'm speaking too quickly for the court reporter. The subjects I plan to cover are briefly the communications that Westlands and San Luis and Delta Mendota Water Authority had with Reclamation, the assumptions that went into the about California WaterFix operations that went into the witnesses' opinions, the level of certainty associated with those opinions, rights in stored water, and those will be different than the questions that Mr. O'Laughlin and Mr. Cooper asked. How the witnesses relied on the modeling. There's a couple of subparts to that. And then regulatory requirements that were assumed as part of these witnesses' analyses. And to begin, I've got a couple of cross-examination exhibits that are new that I'll provide to the dais and to the witnesses.
Mr. Becerra, before you begin, I was busy scribbling and lost track of your last topic item after modeling reliance.
Yes, the last topic will be the regulatory requirements that these witnesses assumed in developing their opinions.
Okay, that's assumed and not speculate.
Correct.
Thank you.
Thank you. So, Mr. Sahlberg, preliminarily, earlier today, you testified that prior to your testimony today, you had had communications with counsel for Westlands Water District and San Luis and Delta Mendota Water Authority to prepare for your testimony today, correct?
That's right.
And those communications occurred, I believe you said, within the last 2 weeks?
That's correct.
And were those the only communications you've had with those two entities regarding your testimony today?
That's correct.
Did those communications occur after protestants submitted their cases in chief no later than September 2nd?
I believe so, yes.
Was the purpose of those communications to discuss preparing testimony concerning protestants' Part 1B evidence?
No.
What was the purpose of those communications?
The purpose of the communications were to discuss the topic of so-called Term 14 that was presented during cross-examination of other panels by, I think, Mr. Lilly, and to discuss the shortage provisions in the contracts.
Are those subjects discussed in the case in chief that you submitted for this hearing?
The Term 14 is not. I may have touched on the shortage. I have discussed shortage provisions in various contracts in my testimony.
In your testimony today, you discussed certain specific CVP water service contracts, correct?
Yes.
Does any of your testimony for the case in chief cover any of those specific contracts that you discussed today?
Specific contracts, no.
Did the counsel for Westlands or San Luis and Delta Water Authority specifically direct you to those specific water service contracts for possible testimony today?
We discussed them. I don't understand what you mean by direct me to them.
Did they ask you to prepare testimony regarding the specific CVP water service contracts that you discussed under cross-examination today?
Not ask me to prepare testimony.
What did they ask you to do in that regard?
They asked me what I knew about these provisions and asked me what I knew about these provisions, and went over some possible questions about the provisions that, shortage provisions and Term 14.
Did they indicate that they would be asking you questions about those shortage provisions in cross-examination
Yes,
today?
they did.
Did the Council for Westlands and San Luis and Delta Mendota Water Authority provide you any information to prepare for your testimony today that you did not previously have?
Provide me with a copy of excerpts from decision 1356 and Water Rights Order 70, which amended 1356. I'm sorry. Water Rights Order 70. Okay.
So you had not previously reviewed those documents in preparing your testimony for the case in chief here today?
No.
Okay. Thank you very much. Moving on to my next subject for discussion, Mr. Baker, if you could please pull up Exhibit DWR 53 and specifically page 3. And then if you could scroll down to lines 22 through 25, please. Ms. Sergeant, if you could refer to that sentence, lines 22 through 25, and in particular on lines 24 to 25, it states, the CWF can be constructed and operated without injuring other legal users of water. That's your testimony, correct?
Yes, it is.
And the CWF is the California WaterFix in this case, correct?
Correct.
Okay. Mr. Baker, if you could please pull up Exhibit DOI 4 and specifically page 6.
Did you ask for DOI or?
DOI 4, yes. And then if you could scroll down, please, to the first paragraph under heading 6. Mr. Sahlberg, do you see the second sentence there that starts with the phrase, as was discussed? And then that sentence ends with the statement, the CWF can be operated in a manner that will allow for all legal obligations of the CVP to be met. That's your testimony, correct?
Yes.
Thank you. Ms. Sergeant and Mr. Sahlberg, in these pieces of your testimony, why did you testify that the WaterFix could be operated to comply with legal obligations rather than it will be operated to comply with legal obligations?
I think I can answer for myself in that in our testimony, we are demonstrating to the board that the project can be operated in a manner that protects legal users of water, because we will, and I believe that's the way my testimony is presented, we will continue to meet all of our contractual and legal obligations. We have indicated that we will continue to meet those obligations. The fact, a statement that it can be operated was just an indication to the board that there is sufficient information that we believe has been presented to the board to show that this is feasible and that we will continue to meet all of our obligations.
Mr. Sahlberg?
You don't have anything to add to that?
Okay. Ms. Sergeant, you just said that it was feasible for the projects to operate in compliance with their obligations to other legal users of water with Cal WaterFix in place. Will they in fact do so?
When I said it's feasible to do so, that means that what I meant by that is that all of the information shows that the project can be operated that way. There's nothing in the information that I reviewed that indicated it would not be feasible, there's anything that would prevent us from continuing to meet all of our obligations.
Again, you just stated that it was feasible for you to meet your obligations. To the best of your knowledge, have DWR and Reclamation proposed any requirements to ensure that you will, in fact, satisfy those obligations to other legal users of water?
I believe that your question misstates what I said. I guess feasible is, I'm using it in more of an engineering term, is that the information provided, I guess as an engineer, I look at something and you do a feasibility study. Is this feasible? And if it is, then you go ahead, and there's nothing that I've seen that shows there's anything in the information provided that would impair the ability of the projects to meet all of its obligations. I believe that we've stated, all of the panels have stated that we propose to continue to meet all of our obligations as we have done in the past. We take our obligations, both contractual and regulatory obligations, seriously, and we operate the project to meet those obligations, and we will continue to operate the project to meet those obligations.
Mr. Sahlberg, do you agree with Ms. Surgeon's statement for purposes of Reclamation's operations?
Yes, the United States will continue to meet all its legal, regulatory, and contractual obligations.
Do you believe there's any uncertainty on this point, considering the broad scope of possible California WaterFix operations?
I don't know how to restate it. The projects are not going to operate in a manner that would lead us to not meet our regulatory obligations. There are certainly conditions under which it is a challenge to do so, such as, I mean, like I said, I think I mentioned before, there's been a lot of discussion about the TUCPs in the last couple of years' obligations. Those conditions are driven by hydrology, and I don't think anyone could ever say that there is never going to be a circumstance when we wouldn't have to ask for relaxation of some of the standards. We've had to do it in the past. In these very critically dry years, that will likely occur in the future. It is unrelated to the California WaterFix facilities.
Mr. Sahlberg, do you agree with Ms. Surgeon's testimony on that point?
Yes, I do.
And you're both aware that DWR and Reclamation have stipulated that you have submitted no proposed terms and conditions to govern the operation of California WaterFix in your water right permits, correct?
I believe that misstates DWR's position.
Okay.
DWR is going, the terms and conditions would come after we have gone through this process. It's correct that at this time we haven't proposed terms and conditions, and I think we had a number of discussions on that topic.
And your testimony is that with the information you have available to you today, which therefore includes no terms and conditions, California WaterFix would operate to injure no other legal user of water, correct?
I believe my testimony is that DWR and Reclamation have operated historically to meet D1641, all of our regulatory obligations, and all of our contractual obligations, and we will continue to do that.
Thank you. Mr. Sahlberg, that's also Reclamation's position?
Yes, it is.
Okay, thank you. Moving on to the next topic, if we could, Mr. Baker, if we could go back to Exhibit DWR 53 and specifically page 8. And then if we could scroll down to lines 25 and 26, please. Ms. Surgeon, this is your testimony, and on lines 25 and 26, you state the CWF petition for change does not propose any changes to upstream operational criteria, correct?
That's correct.
What do you mean by the term upstream operational criteria in this testimony?
Well, I believe that Mr. Lehi went into this as well, but I consider that to be all of the requirements at Lake Oroville, whether they be flood control, minimum in-stream flow requirements, temperature requirements at the hatchery, the obligations under the water right settlement agreements.
And so in that case, you mean regulatory requirements?
Regulatory and contractual requirements.
So you mean existing legal obligations when you say operational criteria, correct?
I mean the operational criteria for the for Lake Oroville.
And by that, legal obligations to which the Department of Water Resources is subject.
As well as the requirements of the power plant and as far as any of the operations related to Lake Oroville. The California WaterFix does not propose to change any current operations, operational criteria at Lake Oroville.
So your testimony is that DWR will not change the operations of Lake Oroville with California WaterFix in place. Is that correct?
That's not correct.
Oh,
I said the
what do you
operational
mean?
criteria will not change. We will continue to meet all of those. And I believe Mr. Lehi went into quite extensive testimony on how there may be some changes in certain years. There may be temporal changes throughout the year, but none of the criteria will change. And there could actually be some additional releases from storage in years when, in the wetter years, when there is sufficient storage in Oroville. That storage may be at risk of spill the following year. So there may be changes that happen at Lake Oroville, but there will be no change in the operational criteria at Lake Oroville.
Okay. If we could, Mr. Baker, if you could please pull up Exhibit DWR 324 and specifically page 5. And then scroll down below the paragraph. I'm sorry. So page 5, and then there's a paragraph numbered 6. And then I have a question about a couple sentences after that. Okay. So, Ms. Surgeon, you have incorporated this exhibit into your testimony, correct?
Yes.
And do you see in that paragraph following the numbered paragraph, there's a sentence that says, the proposed change does not include changes to upstream operational criteria. Therefore, the upstream flow regime will not change as a result of the proposed facilities. That is, you've incorporated that into your testimony, correct?
Yes, I have.
When you use the phrase upstream operational criteria in this instance, do you mean what you just explained relative to Exhibit DWR 53?
Yes, I do.
Okay. Mr. Baker, could you please pull up Exhibit DOI 5E, please, and specifically the last page, which is the 24th page, although I don't believe it's numbered. Hey, Mr. Sahlberg, this is your PowerPoint, correct?
Yes.
Okay. And it states CWF will not alter upstream operational criteria. You just heard Ms. Surgeon explain what she meant by upstream operational criteria. Is that the same definition of that phrase that you have used in this exhibit?
Yes.
Okay. Could we now pull up Exhibit, Mr. Baker, please pull up Exhibit DWR 4E and specifically page 35. Thank you. This is Mr. Lehi's PowerPoint. Under his second bullet, he has the statement that the proposed CWF North Delta diversions could increase opportunity to use existing water rights, including rediversion of stored water under balanced conditions. In stating, Mr. Sahlberg and Ms. Surgeon, in stating that California WaterFix would not alter any upstream operational criteria, Did you consider any changes to the operations of the CVP and the SWP necessary to take advantage of this opportunity identified by Mr. Lehigh?
Again, I think I've described how there may be some changes in the actual operations. There's no change in the operational criteria. I believe Mr. Lehigh went into quite an extensive discussion about the opportunities that might exist to use the flexibility of an additional point of diversion to divert unregulated flow and then redivert stored water during balanced conditions. I think he made it clear that it was unlikely that any greater quantity of water might be released during the drier year types, but some of that water released might be diverted at an alternate location once it reached the delta.
Okay, Mr. Sahlberg, do you agree with that statement relative to the operations of the CVP with Cal WaterFix in place?
Yes.
To both witnesses, in developing your opinion that if the State Water Board were to approve the California WaterFix change petition and that no legal users of water would be injured, did you consider any of these changes to CVP and SWP operations that would be necessary to take advantage of the increased opportunity to divert water, stored water, identified by Mr. Lehigh?
Well, I think I've stated that the water being released is water that is stored exclusively under DWR's water rights, that the modeling shows that there will be no change in end of September storage, and that that we can continue to meet our obligations in the Delta as well as upstream. So yes, I considered that there might be some small change in the way that the facilities are operated with a new point of diversion, but there was nothing to indicate that it would result in any injury to other legal user of water because of a slight change in the way the project might be operated on any particular day.
And Mr. Sahlberg, is that also how you analyze this issue for purposes of Central Valley project operations?
Yes.
Okay. So, Ms. Surgeon, I just heard you explain that you relied on the modeling to identify any possible operational changes with Cal WaterFix in place. Is that correct?
I reviewed the modeling and the results, the graphical results of the modeling, and I looked at the modeling to see what changes there might be.
Mr. Sahlberg, did you conduct the same analysis?
Yes, I did.
Thank you. Did either of you rely on any other information to identify possible CVP and SWP operations as identified by Mr. Lehigh to enable increased rediversion of stored water?
Excuse me, I'm sorry, I guess I didn't understand your question. Any other operations?
I'm sorry. You said you relied on the modeling, reviewed modeling, correct?
I reviewed the modeling results, the graphical modeling results, that's correct.
Is there any other information that you reviewed for conducting the analysis you just explained?
I think earlier I described the other information that I used in my analysis, including the DSM-2 modeling results from Dr. Nader Tehrani, as well as his review of the water level information. And I did look at information in the EIR documents as it might be relevant to this. That's basically the information that I
Mr.
evaluated.
Sahlberg, I'm sorry.
I'm sorry. I evaluated, I'm sorry.
Mr. Sahlberg, did you conduct the same analysis for reclamation?
I reviewed like I earlier stated, I reviewed the modeling results provided by DWR to arrive at that conclusion.
Hold on a second, Ms. Sheehan?
This is Becky Sheehan from State Water Contractors, and I'd just like to point out that these questions have been asked and answered. The witnesses have repeatedly stated that the upstream requirements will continue to be in effect as they currently are, and that there may be some changes. And they've stated this for quite some time repeatedly in these proceedings, and it seems like it might be time to move on.
Mr. Becerra? Obviously, you didn't, or at least you weren't satisfied by the answers that you received from Mr. Lehi and the operations team, and are exploring it further with the water rights team. So help me understand what you hope to get from them that you did not get from operations.
Yes, these witnesses have provided specific testimony that, in their opinion, as the administrators of the water rights for the State Water Project and the Central Valley Project, that all operations would not result in injury to legal users of water. I'm entitled to explore what these witnesses considered in reaching their unique conclusions.
I agree that you are entitled to explore it, and you have explored it. They've said they've relied on modeling, they've relied on discussions and testimony from operations. I'm not sure what else you can get from them at this point.
And that I had essentially reached the conclusion of that with one caveat. Ms. Surgent just testified that she also reviewed information from the EIR. I'd like to understand what information that was.
All right.
I looked at the water quality. I looked at the recirculated draft EIR and looked at the water quality and water supply information that was contained in that, as well as I reviewed the groundwater section. I briefly looked at the others, but not other sections, but not with respect to preparing my testimony.
Thank you. Mr. Baker, if we could pull up Exhibit DWR 324 and specifically page 5. And then scroll down, please, to the paragraph below the numbered paragraph 6. Back to page 5. There we go. Thank you. Ms. Surgent, do you see the sentence there that begins the proposed change? We talked about this a little bit, but for the record, the sentence states, the proposed change does not include changes to upstream operational criteria. The proposed change does not include changes to upstream operational criteria. Therefore, the upstream flow regime will not change as a result of the proposed facilities. That's your testimony, correct?
Yes, it is.
What do you mean by the phrase, the upstream flow regime?
By that I mean essentially the release of natural flow. There may be some changes to the release of stored water, but those changes are all within the existing requirements. There will be no change, and the other thing that went into my determination was there's no change in the minimum in-stream flow requirements.
Okay, let me make sure I understand that. So you're saying that the minimum stream flow requirements in the upstream streams would not change, correct?
That's correct.
But you're saying that it's possible the actual flows in the upstream streams could change as a result of California WaterFix operations,
That's
correct?
correct. That's correct.
Mr. Sahlberg, is that your understanding as well?
Yes.
Okay. So you are not guaranteeing that there will be no changes in actual flows as a result of California WaterFix operations?
No, yes, I'll clarify. I agree that there will be some change in the flow, possibly in the Feather River or Sacramento River at times due to the operation of the facilities if releases are made on a schedule that's temporarily slightly different than it is now. But none of those changes would affect other legal users of water.
And Mr. Sahlberg, is that essentially your testimony for the operations of Central Valley Project facilities concerning the flows in the Sacramento and American rivers as well?
Yes.
Thank you. For purposes of giving that opinion, are you relying on the modeling prepared by Mr. Munivar for this hearing?
With respect to the changes in the minimum flow criteria, or no change in the minimum flow criteria, I relied on the agreement that we have with Fish and Wildlife for minimum flows, and the WaterFix does not propose to change anything in that agreement.
And for the possibility that real flows may actually change, you're relying on Mr. Munivar's testimony concerning that?
I relied on the modeling results for upstream reservoirs, as well as Mr. Lehi's testimony regarding real-time operations.
And what information precisely about real-time operations did you rely on to determine whether or not there would be changes to actual flows as a result of California WaterFix operations?
Discussions with operations that there could be, I think I mentioned before that there could be changes in the exact timing of when water might be released in any particular year, but that by the end of the year, the end of September storage would be the same. And in the modeling results, it shows some slight differences in the curves between the various alternatives temporarily, but by the end of September, the storage levels are relatively unchanged.
And Mr. Sahlberg, does that reflect your testimony concerning reclamation operations?
Yes.
Thank you. Ms. Surgeon, you've said a few times that you've reviewed the modeling in general terms. When you say the modeling, are you referring just to the exhibits that Mr. Munivar has submitted for this hearing, or are you referring to something else as well?
I believe I said I reviewed the graphical representations of the modeling results.
That Mr. Munivar submitted for this hearing?
That's correct.
Have you reviewed any of the other modeling results that Mr. Munivar may have produced?
I reviewed the modeling, the graphical modeling results that showed deliveries as well.
And Mr. Baker, could you please pull up Exhibit DWR 514, please? Ms. Surgeon, when you refer to all of these results, you're referring to this exhibit, is that correct?
This exhibit, as well as the information that's contained in the recirculated draft, EIR.
In the recirculated draft EIR?
With respect to the water supply section, yes.
Okay, thank you very much. If we could pull up Exhibit DWR 3 and page 3 of that. Ms. Surgeon, this is your PowerPoint, correct?
That's correct.
And in it you state that the SWP will be operated consistent with all other SWP regulatory requirements, correct?
That's correct.
The State Water Project is subject to, its diversions in the South Delta are subject to a permit issued by the United States Army Corps of Engineers, correct?
That's correct.
And what limitations does that permit impose on South Delta diversions for the State Water Project?
That would be better answered by Mr. Lehi. I believe he went into that in his testimony as well.
Okay. But you are assuming that you would continue to comply with that permit and making this statement in your PowerPoint?
That's correct.
Would that permit's limitations apply to diversions at the North Delta diversion?
As Mr. Lehi testified, he doesn't believe they would apply at the North Delta facilities.
Thank you. Moving on to rights in stored water, Mr. Baker, if we could please return to Exhibit DWR 53 and particularly page 11. Ms. Surgeon, you have a statement there beginning on page 10 that reads, and I'll omit the parenthetical, but it reads, although there may be changes in SWP, CVP storage levels or releases, this would not injure other legal users of water because it is my understanding that such water users do not have a right to stored water releases from the SWP, CVP. That's your testimony, correct?
That's correct.
Okay. You are involved in the administration of water supply contracts involving DWR, correct?
I do not administer the contracts, no.
In your testimony, you state that, or you had quite a bit of discussion with Mr. Cooper about DWR's supply contracts on the Feather River.
That's correct. I am familiar with the contracts.
Okay.
And there are particular proposals that may relate to one of the contractors or water diverted in a particular area. So I oftentimes review a proposal for consistency with the contracts, but we have a separate group within the State Water Project Analysis Office that administers the contracts.
Thank you. I appreciate the clarification. Mr. Sahlberg, you're involved in the administration of Reclamation's water supply contracts, correct?
Not currently.
Not currently. Have you been?
When I first started at the Bureau in 2000, I was.
Okay. And you are currently the water rights officer for the Mid-Pacific region of Reclamation, correct?
Correct.
And you have offered testimony regarding a variety of CVP water supply contracts, correct?
Yes, I have.
Okay, thank you. Ms. Surgent, could DWR grant another water user a right in its stored water as part of a contract?
I'm not, what do you mean by can it grant a right? Would we assign a portion of our water right to another water user? Is that what you're asking?
No, just you could have a water supply contract that involves the supply of stored water to a different water user, correct?
We have water supply contracts with 29 State Water Project contractors that involve the delivery of project water.
Okay, thank you. And Mr. Sahlberg, Reclamation could have contracts and providing for the delivery of stored water to other water users, correct?
Objection calls for a legal conclusion. Central Valley Project Improvement Act has specific guidance regarding new contracts.
The question, Mr. Becerra, was whether there are contracts.
No, he asked whether they could enter into a contract.
Mr. Becerra?
It's fine. We'll skip the subject.
Yeah, let's.
Mr. Sahlberg, I'll refer you to your testimony, Exhibit DOI 4, specifically the last sentence, specifically page 9. On page 9, there is a paragraph that begins, finally, there are 5 settlement contracts. We could go to that, please. Thank you. Do you see that sentence, Mr. Sahlberg?
Yes.
Are you aware of the existence of San Juan Water District?
Yes.
Are you aware that San Juan Water District receives water that Reclamation diverts directly from Folsom Reservoir?
Yes.
Are you aware that San Juan Water District delivers water for municipal and industrial use?
Yes.
At the end of the sentence on page 9 of Exhibit DOI 4, you have a reference to Exhibits DOI 23 through DOI 27, correct?
Correct.
And those are contracts involving the United States?
Yes.
And specifically operations of reclamation?
Yes.
Do any of those contracts involve San Juan Water District?
San Juan does have a water rights settlement contract with the Bureau.
Are any of the exhibits that you've referenced in this sentence, any of those contracts, San Juan Water District settlement contract?
Don't believe we included San Juan's as a sample of one of those contracts, no.
Okay. I have given you a document marked Exhibit SJWD 10.
Yes.
It's a copy of a 1954 contract between the United States and North Ditch Company, correct?
That's what it says, yes.
To the best of your knowledge, is this San Juan Water District settlement contract?
I believe it's the predecessor to it.
Okay. Did you consider San Juan Water District settlement contract in preparing your opinion that Cal WaterFix could be constructed and operated without injuring another legal user of water?
Yes.
How did you consider that contract in developing that opinion?
It is a water rights settlement contract is one of the, one of the types of contracts that we meet first before we allocate water for other project purposes. So they would be met first, and the modeling shows that that we can make deliveries of water while meeting all our statutory and regulatory and contractual obligations, including this contract.
And you just said modeling indicates. What modeling is that?
That would be the modeling shown in DWR 514.
Thank you. Why did you not submit a copy of this contract as part of your testimony?
We submitted samples of contracts of each type rather than every contract we have with everybody, mostly to save space and time. It would have been well over 300 contracts we would have submitted for the record.
Thank you. Are you aware of the minimum level of water storage in Folsom Reservoir that is necessary for San Juan Water District to obtain its water supply under this contract?
That would be a question for the operators.
So you are not aware of that minimum level of storage?
No, I am not.
Okay, thank you. Mr. Sahlberg, referring back to your testimony, your exhibits, actually, why don't we go back to Exhibit DOI 4, page 9, that same section. Thank you very much. At the end of the paragraph that begins finally, you have the reference to exhibits DOI 23 through DOI 27, correct?
Correct.
And exhibits DOI 23 through DOI 25 reflect Reclamation's water right contract with the city of Folsom, correct?
I'm sorry, could you say that again?
Sure. Exhibits DOI 23 through DOI 25 reflect Reclamation's water right contract with the city of Folsom, correct?
Yes, that's correct.
And are you aware that the city of Folsom obtains its water supply under that contract through a water supply intake in Folsom Dam?
I'm aware of that.
Are you aware of the minimum level of water that needs to be stored in Folsom Reservoir for the city of Folsom to take delivery under that contract?
I am not.
Thank you. If we could please pull up Exhibit Roseville 5. Mr. Sahlberg, you testified about this exhibit previously. This is Decision 893 by the State Water Rights Board from 1958, I believe. Are you familiar with this decision?
Yes, I am.
Thank you. If we could please go to page 5. And if we could just scroll down a little bit further. Thank you. In your testimony earlier today, you stated that you understood this decision to have been precipitated by a number of water right applications on the American River, correct?
That's correct.
Could you please read the first paragraph displayed here, beginning application 12295?
Okay.
Based on this, is it your understanding that the city of Roseville had its own water right application pending at the time of this decision?
It appears so.
Do you know whether or not that water right application was granted?
I believe it was not.
Thank you. If we could please go to page 54 in this document. If we could please scroll down a little. In the first paragraph on this page, there is a text, if we could, there you go, thank you very much. There's text in this decision, I'll read it just so the record's clear. This is, again, statements by the State Water Rights Board. Permits are being issued to the United States to appropriate enough American River water to adequately supply the applicants naturally dependent on that source, and availability of water to such applicants is reasonably assured by the terms to be contained in the permits to be issued to the United States, restricting exportation of water under those permits insofar as exportation interferes with fulfillment of needs within Placer, Sacramento, and San Joaquin counties. Other applicants in more remote areas must, if necessary, seek water from other sources. So you familiarized yourself with Decision 893, correct?
Correct.
Okay. Earlier today, you testified about Term 11 in Reclamation's water right permits, numbers 11315 and 11316, and we can pull those up if you like. Would that be helpful?
If you like.
Okay. I believe they are in Exhibit BKS 1. This is Exhibit BKS1. Mr. Sahlberg, do you understand the highlighted text on this page 1 of this exhibit to be Term 11?
Yes.
Thank you. The portion of D893 I just read, do you understand that to be the basis for the adoption of this Term 11 in Reclamation's permits 11315 and 11316?
Yes.
Thank you. If we could please go to Exhibit Roseville 11. Mr. Sahlberg, this is a Warren Act contract between the United States and the city of Roseville, correct?
That's what it says.
And I know you answered this question earlier, but could you please explain generally what a Warren Act contract is?
Yes, a Warren Act contract is a contract between the United States and somebody who has a non-project, a source of water not appropriate in Reclamation's water rights that seeks to use Reclamation's facility for storage or conveyance of that water.
And specifically as to Exhibit Roseville 11, do you have an understanding of what the source of water is that Roseville obtains through Reclamation's facilities under that contract?
No, I don't.
You don't, okay. Do you know if it's under a different entity's water rights?
Yes, I believe so.
What entity do you believe?
I believe it's Placer County Water Agency.
Thank you very much. Do you have an understanding as to the minimum level of water stored in Folsom Reservoir that is necessary for the city of Roseville to obtain contract water from Placer County Water Agency through this Warren Act contract?
No, I don't.
Thank you. Mr. Sahlberg, Mr. Baker, can you please pull up Exhibit DWR 14, particularly page 17? Oh, I'm sorry. Exhibit 514. My apologies. And page 17 of that exhibit. Mr. Sahlberg, did you rely on this figure 14, and Exhibit DWR 514 in developing your opinions about Cal WaterFix's effects on other legal users of water?
It was one of them.
Thank you. Do you understand that 90,000 acre-feet of storage in Folsom Reservoir is the minimum amount of storage in that reservoir that is possible for CalSim to model?
I'm sorry, repeat that.
Sure. Do you see on Exhibit 514, specifically Figure 14, each of the curves reaches a level of approximately 90,000 acre-feet at a bare minimum, roughly 5 to 7% of the time.
Okay.
Is that your understanding of this exhibit?
Yes.
And was that your understanding when you relied on this exhibit in developing your opinions?
Yes.
Thank you. Do you understand that's the minimum level of Folsom Reservoir storage is possible for California water, for
Objection.
CalSim? Sorry. Yes. Let me repeat the question. In developing your opinion that the operation of California WaterFix would not injure any other legal users of water, did you rely on this exhibit and figure?
Yes.
Thank you. Is it your understanding that 90,000 acre-feet of water in Folsom Reservoir is the minimum that CalSim is capable of modeling?
Objection. Assumes facts not in evidence. Mr. Becerra has not laid the foundation that that's an assumption in CalSim.
Mr. Becerra?
It's not an assumption. As I understand it, it's a result as demonstrated by the fact that Mr. Munavar testified to this as an accurate representation of his CalSim modeling. And judging by the exhibit, it is not possible for CalSim to model a lower level of storage in Folsom Reservoir.
Mr. Selberg, what is your understanding of this graphics and the 90 level,
Yeah.
the 90,000 acre feet level there?
My understanding of it is that, as Mr. Becerra said, in 5 to 7% of the year's model, that it goes to 90,000 feet, including under the no action alternative.
Thank you.
Chair Dudek, if I could just clarify
Yes,
something.
sure.
There was a considerable amount of discussion in the operations panel and the modeling panel over this, this realm of the these graphs. And there was a considerable amount of discussion to say that this is how the models operate. It is not how the operators operate. And so the key to take away from a lot of these graphs is that there is essentially no change from the no action alternative. But before the projects ever got to a level like this, many different operational changes would have happened. There would likely have been, a petition to the water board. The function of getting to this location is not a function of WaterFix. It is a function of hydrology, and the models can't pick up all of those operational things that would be taken into consideration before we get to this point. So I don't know how much more we have to dwell on the very low level when it was made very clear by the other panels that this is not something that the operators operate to.
Thank you. I appreciate the clarification, Ms. Surgent, but you relied on the modeling to develop your opinion that there would be no injury to legal users of water as a result of the implementation of Cal WaterFix, correct?
I believe we testified that we relied on the modeling as well as the operations testimony and discussions with the operators.
And Ms. Surgent, to the best of your knowledge, have DWR and Reclamation proposed any terms and conditions to control their real-time operations of the projects to ensure that these conditions do not occur?
Asked and answered, Mr.
Thank you very
Becerra.
much. Actually, if I can tell you where I'm going with this in light of the clarification.
Please.
Mr. Sahlberg has just testified that there's at least 2 water rights settlement contracts for diversions from Folsom Reservoir that must be met. And so I'd like to ask him whether or not this sort of operation is realistic, even in the no action alternative, for purposes of developing his opinion.
You can ask him, but I won't put answers in his mouth, but keep in mind, we've been reminded by Ms. Sargent as well as others that the model results are intended to be used for comparative purposes, not predictive.
I understand that they're the only basis of information I've got to understand the basis for their opinion that the project would not injure other legal users of water.
Mr. Bodliner?
Well, that and hours and reams concerning operations. So we've been around this block so many times. I mean, we've been through it with the modeling panel, with the operations panel. We're going through it again. The answers are all the same.
Thank you, Mr. Bodliner. I will allow Mr. Becerra a little bit of leeway because this is an important issue, and I believe Mr. Becerra understands the limitations to which these witnesses will be able to answer.
I do, thank you. If we could please pull up Exhibit BKS 13. And let's specifically focus on that first page and the top graphic, Folsom Reservoir storage in 1931. Thank you. I'll represent to the witnesses that this graph is modeling results extracted from DWR's modeling that has been made available for purposes of this hearing to reflect Folsom Reservoir storage in the water year 1931 in all of the modeled California WaterFix scenarios. And for purposes of the board, we will be authenticating this in Part 1B. So if you could, Ms. Surgeon and Mr. Sahlberg, if you could please refer to this. Do you see the black line on that graph indicating no action alternative?
I do, yes.
Mr. Sahlberg?
I believe so, yes.
And that black line indicates that the no action alternative would reach 90,000 acre feet in Folsom Reservoir in September of 1931, correct?
That's what the black line shows. Again, I think my answer is the same as before. These are modeling results that the operators have already indicated that this is not how they would operate. They would take measures before these conditions arrived to adjust their operations. And so I don't think that these graphs or the other graphs that show the conditions during the most extreme water supply conditions are reflective of what would happen. 1931, you could look back to 2014, 2015, some of the other critically dry years. We take a number of steps to make sure that to the extent the projects can, they maintain water levels for a number of purposes, but we cannot control hydrology, and we can't guarantee that we won't have another critically dry year like we did in 2015, where snowpack was only 5% of average. But again, those the operations of the California WaterFix facilities in those years would not impact that. This is, and I think this may have been, or something similar may have been shown in some of the modeling in the, or the operations testimony, and I believe they commented with respect to that.
Thank you, Ms. Surgeon. Your testimony is that the California WaterFix in all possible operational scenarios would not operate to injure legal users of water, correct?
That is correct.
Thank you. Mr.
Excuse me, I said the California WaterFix facilities, yes. The operation of the California WaterFix facilities, we believe, will not injure other legal users of water, the operation of those facilities.
In all possible operational scenarios, correct?
Correct, the operation of the California WaterFix facilities.
Yes. Thank you. So referring back to this BKS 13 and the Folsom Reservoir storage in 1931, the black line indicates that in the no action alternative, Folsom Reservoir would reach a minimum of 90,000 acre feet in September 1931, correct?
Just acknowledge that that's what the graph says, and then allow him to proceed with his questions.
Yes, that's what the graph says.
Thank you. And Mr. Sahlberg, do you understand that as well?
Yes.
Thank you. And the other curves reflecting the boundary 1, H3, H4, and boundary 2 scenarios all reach 90,000 acre feet 1 month earlier in August 1931, correct?
That's what your graph shows, yes.
Well, I'll represent to you that this was extracted from DWR's modeling for this hearing.
That's fine.
Fine, with all the caveat you've already stated numerous times for the record.
And Mr. Sahlberg, do you also understand this graph to show that the with action alternatives reached 90,000 acre feet 1 month earlier in 1931?
That's what the graph shows.
Thank you. Do you have any reason to doubt the authenticity of this graph?
Yes, they do, because it doesn't reflect the operational flexibility that is ingrained in the project. When I can answer the questions for the witnesses, Mrs. Becerra, that's a really bad sign.
Thank you, Ms. Dodak. Okay, we'll move on. Could we please refer back to Exhibit DWR 53, and particularly page 10? the bottom, page 10 has a heading 6 for proposed change. Thank you very much. Ms. Surgeon, in this portion of your testimony, you indicate that you've relied on Mr. Munavar's modeling to support your opinions. Is that correct?
Objection asked and answered.
Okay, thank you.
Let's just assume everything that's in her testimony is correct, according to her.
Thank you. And on page 11 of this testimony, lines 20 through 26, particularly on line 24, you state that you make a statement about carryover storage levels, correct?
Correct.
What do you mean by the term carryover storage levels?
I mean the storage remaining at the end of the season.
And by the end of the season, you mean end of September?
In this case, end of September.
Okay. Mr. Sahlberg, do you agree with that characterization?
Yes.
Thank you. Did you consider any other monthly storage levels in developing your opinions?
I did not, because the reservoir levels fluctuate routinely depending on the conditions in any particular year. And all of those operational those changes were well within the normal operating criteria of the reservoir.
So you did not consider any possible changes in reservoir storage as a result of California WaterFix operations in developing your opinions?
I reviewed, I think I stated this before, I reviewed the information that was in the graphics, and I did not see anything in the graphics that would indicate to me that the operation of the WaterFix would affect our ability to meet our contractual obligations. In no circumstances did it appear to drop below a point that we could meet those obligations as opposed in comparing this operation to the no action alternative. We can make decisions to release a little additional water in May and a little less water in the middle of the summer. We still arrive at the same location at the end of the season, which would bring us into the same position the following year.
So just to repeat the question to make sure I get the answer, you did in fact consider end of month storage in other months besides September in developing your opinions?
Maybe I wasn't clear in my answer. I looked at the end of month storage graph. I didn't see anything in there that would indicate we couldn't meet our obligations. In the modeling or the operations testimony, there is information to say that there could be some changes on timing. However, the end of season storage targets are the same. I mean, and end of September storage targets are the same. So I didn't see anything in that testimony that would make me believe there was a risk to our ability to meet our contractual obligations.
Thank you. Mr. Sahlberg, did you conduct the same analysis?
Yes, I did. I looked at the end of September modeling results and did not see anything in those or any other results that would indicate we would have trouble meeting our legal, regulatory, or contractual obligations.
You said end of September. Did you consider other months besides end of September in developing that opinion?
No, I did not.
Thank you.
Mr. Becerra, you've just reached the end of an hour. Do you have additional lines of questioning relating to modeling reliance, or are you ready to move on to the regulatory requirements?
I do have a couple of additional lines of questioning about modeling. I don't think they'll take that long. If I could go another half an hour, I suspect that would be sufficient.
How much time do you tend to focus on the regulatory requirements?
Not much.
I'm nudging you into that area because I am doubtful you'll get more from these witnesses with respect to modeling reliance, but I will allow you a little bit more time.
I don't think the regulatory line of questioning will take very long, probably
Okay.
10 minutes.
Let's give you another 15 minutes and we'll check in after that. But based on the answers that they've been providing, I don't know how much more you'll get with the modeling questions.
Thank you. Appreciate that. we could pull up Exhibit DOI 4, specifically page 3. And the very bottom of that page, there's a sentence that begins, the CVP's operations, and it states, the CVP's operations are coordinated with the operations of the State Water Project under the terms of the Coordinated Operations Agreement, COA, signed in November 1986. Mr. Sahlberg, this represents your testimony, correct?
Yes.
And so to the best of your understanding, the COA applies to the operations of the Central Valley Project and the State Water Project generally, correct?
Yes.
Are you aware that Mr. Munavar testified that the modeling of delta outflows for alternative 4A-H4 do not allocate the responsibility for those outflows consistent with COA?
Yes, I am.
Thank you. Does it affect your analysis of possible effects of California WaterFix on legal users of water that modeling of that alternative does not comply with COA?
I believe Mr. Milligan and Mr. Lehigh both said that it does not, that particular scenario is at odds with COA.
Thank you. And your testimony that all possible operations of California WaterFix would not injure legal users of water applies to alternative 4A-H4, correct?
Correct.
Does it affect that opinion that alternative, the modeling of alternative 4A-H4 does not comply with COA?
As I said, Mr. Milligan did say that it did not comply with, that it was at odds with COA. I'll leave it at that.
Thank you. Ms. Sergeant, your testimony that implementing California WaterFix would not injure other legal users of water applies to all possible operations within the range between the Boundary 1 scenario and the Boundary 2 scenario, correct?
Well, the project being proposed by the Department and Reclamation is H3 to H4. And at the request of the Water Board, a broader range of potential outflows was analyzed for the purposes of this hearing. And I believe that the modeling results that I showed, evaluated, showed that throughout the range, the project could be operated without injuring other legal users of water. There could be substantial impacts to State Water Project contractors, but it appears that the regulatory and contractual requirements could be met in all those scenarios.
And when you say the range, you mean the range between Boundary 1 and Boundary 2?
That's correct.
Thank you. Mr. Sahlberg, your testimony that implementing California WaterFix would not injure other legal users of water also applies to the entire range between the Boundary 1 and Boundary 2 scenarios, correct?
That's correct.
Thank you. If we could please pull up Exhibit DWR 71 and specifically page 12. And if we could scroll down to lines 15 through 18. This is Mr. Munavar's testimony, and this portion of his testimony states, when system-wide storage levels are at or near dead pool, also described as stressed water supply conditions, the CalSim 2 model results should only be an indicator of stressed water supply conditions and should not be necessarily understood to reflect actually what would occur in the future under a given scenario. Did either of you consider this limitation on Mr. Munavar's modeling in developing your opinions that California WaterFix would not injure other legal users of water?
Objection asked and answered.
Let's state it one more time for the record.
I relied on the modeling results as well as the operations results, and I believe there has been a substantial amount of discussion relating to the fact that, as Mr. Munivar indicates here, it should not, the very extreme conditions at the far end of the probability curve should not be considered as how the project would operate. There are a number of measures that would be implemented before those conditions would become, or before those conditions would exist. And you see very little difference between the no action and the California WaterFix facilities. Again, the California WaterFix does not generate the hydrology that results in those very critically dry conditions.
Mr. Sahlberg, does that reflect your testimony as well?
Yes.
Thank you. To the best of your knowledge, have DWR and Reclamation offered any testimony to describe how California WaterFix would in fact operate in stressed water supply conditions as defined as by Mr. Munivar?
I don't believe we have offered any specific testimony. We have the, as to any particular year and how that would operate in those very critically dry years. So much depends on that specific year. As I'm assuming that the same procedures that have happened in the recent critically dry years would occur in any similar conditions in the future. DWR and Reclamation worked very closely with a very broad range of other resource agencies, including the Fisheries Agency, the State Water Resource Control Board. And so it's very difficult to say what would happen. What would happen with the California WaterFix facilities would likely depend on what water quality objectives we're controlling and what effect operation at any particular location might have on aiding the projects in meeting, to the best of their ability, those objectives.
Thank you. And does, Mr. Sahlberg, does Ms. Surgeon's statement just reflect your testimony as well?
Yes.
Thank you. If we could please refer back to Exhibit DWR 324. And specifically, page 1. The bottom of the first paragraph, there's a sentence that starts "since that time," and it reads, "Since that time," which is the filing of the change petition. "Since that time, additional information has been released, including CalSim DSM-2 modeling and Reclamation's January 2016 draft biological assessment, BA." Ms. Surgeon and Mr. Sahlberg, you've both incorporated this statement into your testimony, correct?
That's correct.
And was this CalSim modeling referenced in this sentence, was that the modeling to support the draft biological assessment?
There was calcium modeling done to support the biological assessment. There was also calcium modeling done as part of the WaterFix petition.
And
So
those were...
you're referring to the calcium modeling here. I'm not aware of whether there was additional calcium modeling done for other purposes, but there was modeling done for the biological opinion.
Oh. For the biological assessment?
I'm sorry, the biological assessment, yes.
Thank you
that's
very
correct.
much. Did you rely on that biological assessment modeling for any purposes in developing your opinions?
I did not.
Okay.
I did not.
Okay. If we could please refer to Exhibit BKS 14. This is a new exhibit that I provided today on the thumb drive. It is, for these purposes, it's the letter that I provided in the pack of 2 documents at the beginning of the cross-examination.
Where is it here?
I can get my thumb drive back and provide it. That will just take a second. I thought I had done that earlier today.
Everyone stand up and stretch while he's doing that.
Nice.
All right, it is up.
Thank you very much. I'm happy to ask questions while you're standing if you like, but... Oh, that's no problem. Have either of you ever seen this letter before?
I have not.
Ms.
I have
Sargent,
not.
if it's helpful, you may stand there and use that microphone.
Thank you. That would be helpful.
Mr. Stallberg, you
I
haven't
have
seen
not.
either? Okay.
No.
Thank you very much. We'll move on to the next subject then. And this is the regulatory requirements, and hopefully this will be short.
Before you move on, this was a March 11, 2016 letter to,
Oh, for the record, this is,
Oh, I'm sorry. Yes, sorry. This is a March 11th, 2016 letter from the Department of Water Resources and the Department of Interior to the Water Board. It responded to the Water Board's May 4th requirement to address certain informational requests. And in particular, just I believe it's the last page, there's a highlighted section. And I added the highlighting, and it states that the department and the two departments would be submitting the modeling conducted for the biological assessment for their case in chief. And just the point is, the two witnesses just said that they'd never seen this before and didn't rely on the biological assessment modeling. So we'll be done with that. Moving on to regulatory requirements, if we could pull up Mr. Sahlberg's PowerPoint exhibit DOI 5.
five or five errata.
Oh, it would be 5 errata. Thank you. And Mr. Sahlberg, in this PowerPoint, you list all of the water right permits that apply to the Central Valley project, or at least those that are subject to this hearing, correct?
That's right.
Okay, thank you. If we could go to page 13. This page lists permits 11.315 and 11.316, which are the permits for Folsom Dam and Reservoir, correct?
Correct.
Thank you. And if we could go back to exhibit BKS 1, page 1. We've talked about this quite a bit today. This is term 11 in this permit. Mr. Sahlberg, did you have any communications with the modelers about this permit as they were developing their modeling?
No.
Thank you. So you provided no direction to them about how to consider this permit term in developing the modeling?
No, I did not.
Thank you. To the best of your knowledge, does Reclamation intend to comply with this water right permit term in operating California WaterFix?
This permit term is a contracting preference, and I've testified previously. It was to allow, or let me just say, it was to allow entities within Placer, Sacramento, and San Joaquin counties essentially first dibs on the supply of water from Folsom Dam. They had a contracting preference. They got in line first. And as the subsequent decisions, it was extended at one point to December 31st, 1975, and then that extension was rescinded. And the original expiration date on the preference of July 1st, 1968 went back in place.
And that is your interpretation of this permit term?
Yes, it is.
Correct. Is that, to the best of your knowledge, is your interpretation of that term stated in any location in Decision 893?
For example, would be in the last paragraph of the cover letter for D893.
It's in the cover letter.
The cover letter for D893. And there are other places where it is more fully explained, and I believe in decision 1356 and in Water Order 70.
And did you discuss any of the testimony you just provided with the counsel for Westlands Water District and San Luis and Delta Mendota Water Authority in preparing your testimony?
Yes.
Thank you.
Are you about to wrap up, Mr. Becerra?
I am, in fact, wrapped up. I do have a statement. We would like to reserve the right to recall Mr. Sahlberg for further testimony in light of the friendly cross-examination that occurred earlier today. That essentially was direct testimony that was not previously provided. And so we would like the opportunity to review that and potentially come back and ask Mr. Sahlberg about that testimony that was provided.
Let me ask my counsel for advice on this procedural issue. Mr. Williams, your thoughts?
I want to voice my objection on behalf of Westlands, especially as to the characterization that it was direct testimony. It was not direct testimony,
It was definitely friendly cross.
but it was friendly cross-examination, ma'am.
I'm not willing to give people second bites at cross-examination. So, Mr. Becerra, could you give me further details on, well, why you don't think you can go into, I mean, you've spent a little bit of time today already going into some of that. Not being an attorney, I'm hesitant to allow additional cross on cross rather than cross on direct.
I understand that, certainly. It appears that there has been some significant coordination between non-protestants, project proponents, and the petitioners for development of testimony that was provided for the first time today in response to friendly cross-examination. It appears that there has been substantial communications that may be subject to subpoena so that we can understand how Reclamation went about developing the opinions that they expressed for the first time today concerning the effect of Cal WaterFix on other legal users of water.
Mr. Elajim?
Thank you, Madam Chair. The Sacramento Valley group would join the objection, and I would like to add another reason.
I'm sorry, it wasn't an objection, it was a request.
Request. Thank you. It's getting late in the day. What we believe has happened here, and Mr. Becerra brought it out on his cross-examination, is that there was coordination after the submission of the Part 1B case in chief amongst Westlands Council and our witnesses this afternoon. Effectively, what that has turned Mr. Sahlberg's testimony into is rebuttal. And we have an opportunity, we were requesting an opportunity to conduct essentially cross-examination on that rebuttal, and that requires additional time. That is the basis for the request.
All right, I'm not going to rule on that today. I will request, though, should you wish to conduct further cross-examination of these witnesses based on that argument, I will request it in writing, and I will give Mr. Williams, the petitioners, and others the opportunity to respond as well.
Thank you very much. We appreciate
Okay.
it.
With that, Mr. Elajim, how much time do you think you need to clean up your colleagues' cross-examination? Or was it wrap up? I'm sorry.
Thank you, Madam Chair. I think I can wrap up the cross-examination in about 15 minutes.
Okay.
If I may get my computer.
All right. Everyone stand and stretch, and then we'll take a short break after Mr. Elajim finishes his presentation or his cross-examination. Actually, while he's doing that, let me also do a check-in. Group number 8, are you here? Tamacalusa Canal Authority? Have we forgotten our group number already?
Meredith Nickel on behalf of Tehama-Calusa Canal Authority. I do have some probably about 20 to 30 minutes.
Okay, I think what we'll do is we'll end the day with your cross-examination then.
Okay, thank you.
All right.
Madam Chair, point of clarification then. I will have probably, again, 15, 20 minutes, maybe a half hour of cross-examination for the city of Brentwood, which is, I believe, Group 10. And if the chair would indulge me, we could do that next week. Appreciate that.
That is in addition to...
It entirely different focus.
Okay, we will move, and are you the sole cross-examiner for Group 10, or will there be others for Group 10?
To be honest, Madam Chair, I'm not sure who else is in Group 10, but I believe that North Delta will be coming
Aren't you
before us.
coordinating?
We are, but I believe that North Delta will be before that.
Okay, well, I will definitely make a note, Mr. Elajam, representing Group 10 next week.
Thank you, Madam Chair.
Actually, since we can probably wrap up with Mr. Elajam and Ms. Nichols today, why don't we go ahead and take a 5-minute break now, and then that way we'll come back and wrap up the two. Will 5 minutes be enough, or would the court reporter like a little bit longer break? That's fine? Okay. You know what? 8 minutes, and we'll resume at 4:00. I can't add anymore. 4:15? Thank you. right, please get in position, whether it's standing or sitting. And we will now turn the cross-examination over to Mr. Alajim.
Thank you, Madam Chair. For the record, David Alajim, Downey Brand, on behalf of Sacramento Valley Group. Mr. Sahlberg, Ms. Sargent, good afternoon. During our break, I noticed that you were out actually talking to counsel for Westlands and I believe the federal contractors and state contractors. Would each of you share with us what the subject of those conversations was?
I don't believe I had any conversations with the federal contractors or...
Sorry? Oh.
Where is Mr. Sahlberg?
Yes. Oops. Ms. Sargent, you can answer the question while we're here.
I don't believe I had any conversation with the federal contractors beyond saying hello.
Okay. Thank you very much.
Why don't you proceed with any questioning of Ms. Sargent while we're waiting?
I will be happy to. Ms. Sargent, we've been having a lot of conversation this afternoon about the modeled effects of WaterFix, and on a number of occasions you have said that you believe there will be no injury to other legal users of water because real-time operations would prevent those injuries from occurring. Is that a fair statement?
Asked and answered. Objection.
I'm laying a foundation for the following question.
Foundation has been laid. Move on, Mr. Alajim.
Ms. Sargent, I want to ask you, suppose in a particular year, water is exported from Lake Oroville using the California WaterFix project, and there is a reduction in carryover storage for the following year. And in that following year, there is inadequate water to meet downstream flow requirements under the various environmental requirements and the Feather River contracts. Would that then constitute an injury?
Objection. Incomplete hypothetical. Ms. Sargent has already testified that they can operate the reservoirs with existing facilities. So in order to have a complete hypothetical, you'd have to know how the California WaterFix is going to be operated differently than current conditions. And if the questioner wants to pursue that, that's fine. But this is an incomplete hypothetical.
And
Mr. Alajim?
And Ms. Doda, I will be glad to augment the hypothetical. Assume current operations of the State Water Project, adding in the WaterFix project as proposed by the department. So far, so good?
Okay.
Yeah. One of the assumptions that you've made, Ms. Sargent, is that end of September storage would be the same with WaterFix and without WaterFix.
That's correct. I believe that's what the
Now let's change that. Let's change that assumption so that there is 100,000 acre-feet less of carryover storage end of September in Oroville.
Now, we've gone down this path before, and Ms. Sargent, what is your opinion of that scenario that Mr. Alajim is painting?
In the years when low carryover storage into the following year is an issue, I don't see a difference between the current operations or operations with the WaterFix, and I believe Mr. Lehi testified extensively to this as well. And as far as speculating on any condition that might be put up, some hypothetical, I suppose this happened or that happened, I don't anticipate at those in those types of hydrologic conditions that operation of the WaterFix will change the decisions made regarding releases and end of season storage.
Chair Dudek, Ms. Sargent is making two different statements here, and I want to unpack them. The first is she doesn't believe that the hypothetical can occur. She's entitled to her belief, but I'm also entitled to ask her a hypothetical question because she's an expert. Second question is she says that we will be able to manage the WaterFix project so as to be able to avoid injury. With this hypothetical, that's what I would like to explore. And I believe I'm entitled to ask her that question.
You know, I almost reacted to that last entitlement statement because I was about to allow you to answer to ask your question.
Thank you, Chair Doduk.
Go ahead. Let's explore this a little bit. And Sergeant, to the best of your ability, let's play along with Mr. Elijah's scenario.
Okay.
Just as a point of clarification, could Mr. Elijah set forth his question so she can respond to a whole question?
I would be glad to. Let's assume, Ms. Sergeant, that the California WaterFix project is in operation and that in a given year, the department is able to export 100,000 acre feet of water in addition to what it would have been able to do without WaterFix. So exports are increased. Now, we have a year where there is inadequate water to meet the department's obligations under various regulatory requirements, statutory requirements, and its obligations to the Feather River settlement contractors. What would happen then? Would there be an injury to the Feather River settlement contractors?
And for the record, I'm going to object as an incomplete hypothetical because we don't know where the exported water came from. I think the questioner is assuming that it's coming out of storage in Oroville, but that's contrary to Mr. Lehigh's testimony that indicated that they would be capturing, even in a dry year, there are times where it's wet, as in the example that he gave, where he was capturing water below the reservoir, not from the reservoir.
Mr. Elijah, would you like to add to your scenario?
I would add to that this is water that is being captured in the reservoir. So we are pulling down storage. Because we are able to do that, we are able to export, and the premise of the California WaterFix project is big gulp, little sip. So we are storing more water, we are moving it. I'm now exploring what happens in the subsequent year when there is, to use Mr. O'Loughlin's phrase this morning, a hole in the reservoir.
Okay.
I would just like to clarify something with respect to your question. You indicated that the idea with the WaterFix was big gulp, little sip, and that whole idea was that we could take advantage of the high flows in the Delta, the unregulated flows, and export some of those. It was not that we would be drawing down, making additional storage releases from the reservoir to jeopardize our ability to meet our contractual obligations. So I take exception with the characterization of the WaterFix as well as the hypothetical being posed, because I think there was quite a bit of discussion as to the advantages to be seen, and in the modeling testimony they indicate that the majority of the increase in exports is in the wetter year types. John Lehi extensively discussed how even today there are limitations on the exports that result in surplus export capacity at times. So I think there's been a mischaracterization as to just what the WaterFix facilities will provide to the department, and the proposals as to how it will be operated.
Ms. Sergeant, I appreciate your reflections on my characterization of the WaterFix project, but could you answer the question?
Okay, I guess if you can restate it without the additional suppositions on the WaterFix.
Let's assume that the WaterFix project is operated. So there is 100,000 acre feet of less carryover storage in the second year due to that water being exported in the first year. And let's just further assume that given that 100,000 acre foot hole in the reservoir, there is inadequate water to meet all of the biological requirements, other regulatory requirements, and deliver full quantities to the Feather River settlement contractors. Would that then be an injury to those contractors?
I guess I'm struggling with this because I fundamentally disagree with the premise, and I'm trying to picture a scenario where it would be possible, because in order to not be able to meet all of those requirements, it would have to be a series of very critical years. We would have taken steps to preserve a certain level. We have certain target storages that will not change as a result of the WaterFix. So I'm just struggling with the premise of your question, that we are going to do that, because in the type of years when this could possibly be an issue, there are already decisions made to retain water in Oroville to preserve that.
Chair Dudek, I think we've probably exhausted this line, but if I might ask Mr. Sahlberg whether you agree with Ms. Sargent? Let me move on.
Mr. Lodgem, at the risk of interfering, now that you've wanting to move on, because I'm afraid that others will circle back to this, or might circle back, let me make sure that let me try one thing. Putting aside, Ms. Sargent, the WaterFix proposal, if you had a scenario in which carryover storage were reduced by whatever that amount, and as a result, certain requirements and obligations could not be met, putting aside WaterFix, in any scenario, would that be, in your mind, an impact or an injury?
There would be an impact. I don't know that I'm prepared to make
Agreed. Okay.
a determination.
I think that's the best you're going to get, Mr. Lodgem.
And Chair Dudek, I had come to that conclusion, which is why I was ready to move on. Ms. Sargent, let me continue on a discussion that you had, I believe, this morning and this afternoon with Mr. Cooper. He was talking about water transfers and how the department assesses whether or not there's an injury. Could you spend a couple of moments explaining to us the thought process that the department goes through in ascertaining whether there's injury? You said it depends on case by case, and I fully get that. But could you just simply walk us through your thought process?
I'm going to object. This question calls for a huge narrative response. I think it's fair if they want to explore, assuming it's relevant, because I'm struggling as to what the relevance is, but I think we're in a question and answer format at this point on cross-examination, and to ask somebody a question like this that can get a half an hour response, I don't think is a proper question.
Mr. Lodgem?
Let me respond to Mr. Berliner. Ms. Sargent has said many times this morning that the department evaluates these on a case-by-case basis. What I'm looking for are what are the criteria the department uses in making its evaluation, and how do those criteria play into its decision?
That's legitimate. Please answer.
We look at each transfer proposal that comes in, and we look at the methodology that's being used to make water available. We get information that illustrates the operations that would occur absent the transfer. So that will depend on the type again, whether it's crop idling, it would be a crop history. To try to get a feeling for what would happen absent the transfer, and we evaluate the method being proposed for the transfer and try to assess what would be the net reduction in stream flow below that point of diversion, and then we limit the amount of water that we agree to convey through the State Water Project to that amount we determine would be the net increase in water made available as a result of the actions taken for the transfer downstream of that point of diversion.
So let me see if I get this correctly. As long as there is a net increase in the water being made available downstream and then moving through the department's facilities, the department would find there is an injury or not an injury?
There would not be an injury to
Okay.
other legal users if limit our transfer quantity to the amount that the net amount that is made available as a result of the transfer actions.
I have one further question, and it's actually from Mr. Sahlberg. Ms. Sargent, thank you very much. This morning there was some discussion that I believe you had with Mr. O'Loughlin about priorities, about whether the water rights would be met or whether regulatory requirements would be met. And you said that regulatory, statutory, water right requirements are all part of the same, I will use the word bucket. You did not use that. Do you recall that testimony?
Yes.
Does reclamation give any priority to meeting requirements under the biological opinions or other ESA requirements vis-a-vis contractual obligations, or, well, let me just leave it there.
Give me a moment. Our normal practice, meet our water rights obligations first. So we have a pot of water, water rights, regulatory obligations, then water service is basically it.
So if I were to try to describe what you just said on a priority basis, let me see if I get this. The prior water rights obligations, the other regulatory obligations,
Right.
including ESA, and then the water service contract. Is that correct?
That's correct.
Thank you very much. No further questions.
Actually, didn't you have a question for Mr. Sahlberg when he was out of the room? Didn't you have a question for Mr. Sahlberg when he was out of the room?
I thank you, Chair Doduk. Mr. Sahlberg, I'd asked Ms. Surgeon, I'll ask you the same question. I thought I noticed you speaking with counsel for Westlands and some of the other state and federal contractors. Could you share with us what that conversation was?
Ms. Ackroyd?
Rebecca Aykroyd, San Luis and Delta Mendota Water Authority. I'd object in terms of relevance. Does not relate to the testimony from earlier today. And it seems relevant when parties are speaking to each other in the...
All right,
Chair
Mr.
Doduk,
Elijah?
as Mr. Pizzaro was making his point, we believe there's been some coaching going on here, and conversations between the federal contractors and the witnesses are not privileged. I'm entitled to know what they are.
Please answer, Mr. Sahlberg.
When did these conversations take place that you are referring to?
Well, since you've opened that door, I'd like to hear about all of those conversations.
We first had a conversation on this 2 weeks ago. We had a further conversation last week, and we discussed it. We discussed the results of the testimony today.
And when you said discuss the results of the testimony today, when did that occur?
I believe at the last break.
And when you say discuss the results of the testimony, did any of the counsel for Westlands or the federal contractors give you suggestions as to what you should say?
No.
Did they critique what you had said?
No.
What did they tell you?
We talked about the questions that Mr. Becerra had asked.
Could you elucidate further?
They asked about, honestly, no. I don't recall what we talked about. I know it was 10 minutes ago, but it was mostly chit-chat about,
Thank you, Mr. Sahlberg. No further questions.
Thank you.
Chair Doduk, thank you very much for the courtesy of that last question.
Thank you, Mr. Elijah, and we'll see you next week for Group 10 or at least part of Group 10. Ms. Nickel, we're now up to you. I'm looking at the clock. I want to make sure that you feel comfortable. You can cover your cross-examination in the remaining time because we do have a hard stop at 5. As you know, the video and audio shut down.
I believe I can.
Okay, perfect.
Mr. Baker, could you please pull up Exhibit DOI 15?
And please state your name and affiliation for the court reporter and for the record.
I will. Good afternoon. Meredith Nickel for Tehama-Colusa Canal Authority. Thank you. Mr. Sahlberg, my questions will be directed largely to you. And I first want to ask, are you familiar with this contract?
Yes.
And have you ever spoken to any attorney for Westlands or San Luis Delta Mendota Water Authority about this contract?
Not this particular contract.
Have you spoken to any such representatives about a contract similar to it?
Yes.
Which contract?
The water service contracts in general.
Can you be a little bit more specific?
No. If you're talking about a specific contract that we discussed, no, we just talked about them in general.
And are you referring to the discussions you had with those attorneys prior to this hearing?
Yes.
And did either of those attorneys offer any suggestions about the interpretation of this contract or any contract like it?
They asked me what my interpretation of it was.
And what did you tell them?
I told them what I previously testified to.
Okay, thank you. So I want to ask you a little bit more about your understanding and interpretation of this contract, just different aspects of this contract. And also, we're going to talk specifically about this contract, which is the Arland-Artois Water District contract, water service contract. But I understand it's representative of other water service contracts in this division, correct?
Yeah.
And can we collectively call these contracts the Tehama-Colusa Canal contracts, water service contracts?
Yes, this contract is representative of a Tehama-Colusa Canal contract.
Okay, thank you. So can we refer to that as a category of contracts during this discussion?
Sure.
And you can clarify if you need to about specific contracts. So is it your general understanding that Reclamation is obligated to meet the requirements of this contract?
It's required, yes, it's required to meet its obligations.
And is Reclamation also obligated as part of those requirements under the contract to make water in certain amounts available for delivery to the contractor?
Subject to the terms of the contract, yes.
And is one of those terms of the contract the terms regarding when there's a condition of shortage?
Yes.
And is it correct that during a condition of shortage, Reclamation is only obligated to deliver the water that it's able to under that condition, correct?
Correct.
So is it fair to say that Reclamation is obligated under this contract to deliver any water that it is able to?
What is your objection, Ms. Offenberg? Your microphone is not on.
It's vague and calls for a legal conclusion.
I'm asking his expert opinion about the understanding of this contract, and if we want to be more specific, I can point to specific language in the contract if that would be helpful for the witness.
Let's ask Mr. Sahlberg to first, if he can answer the question.
I think it would be helpful if you pointed to specific
Okay.
language.
Okay, let's do that. Let's look at, let's go first to pages 28 to 29, and this is Article 12A. It's language we saw earlier this morning.
Mr. Baker, could you go to a wider view?
Yeah, it's unfortunately the language that straddles the page 28 to 29. So we'll start with this part. Mr. Sahlberg, are you familiar with Article 12A?
Yes.
And let's go to the next page and it refers to a condition of shortage, correct? Article 8A, I'm sorry, Article 12A refers to a condition of shortage, correct?
Yeah. It states that in the event the contracting officer determines that a condition of, I'm sorry, in the event the contracting officer determines that a condition of shortage appears probable, it does refer to the condition of shortage.
Okay. And the condition of shortage is capitalized, so there's a definition, correct?
Correct.
Okay, let's move to that definition, and it's located at page 4 in Article 1C. Mr. Sahlberg, are you familiar with this definition of condition of shortage?
Yes.
And do you see that it defines a condition of shortage to mean a condition respecting the project during any year such that the contracting officer is unable to deliver sufficient water to meet the contract total?
That's what it says, yes.
Okay, so based on this aspect, this term of the agreement, is it your understanding that Reclamation is obligated to deliver any water it is able to pursuant to the terms of this contract?
Objection is to being vague regarding any water that it's able to. There's a distinction between CBP water and other water.
Mr. Sahlberg, what is your understanding of these two provisions that Ms. Nichol has pointed out?
My understanding is these provisions state that it is not always possible to deliver the contract total, which is the max amount of water available under the contract, and that if that we will, Article 12A says we will we'll take reasonable measures to avoid that, but if it happens, then a condition of shortage exists and there's not sufficient water to deliver to meet the contract total.
Ms. Nichol, back to you.
Thank you. And under a condition of shortage only exists when Reclamation is unable to deliver water, correct?
It's unable to deliver sufficient water to meet the contract total.
Okay, thank you. So I want to move back to Article 12, and you started talking about this, Mr. Sahlberg. So can we move to page 29, and this is Article 12B. And this is the provision of the contract that you discussed with Ms. Ackroyd this morning, and colloquially called these a shortage provision, correct?
Correct.
Sorry, it's 12B as in boy. So is it your understanding of this provision that it would limit Reclamation's liability under certain conditions?
Yes.
And would it limit Reclamation's limit Reclamation's liability for reduced allocations under this contract that would result from this project?
Yes.
Can you explain how it would do that? How would this provision limit Reclamation's liability resulting from reduced allocations under the proposed project?
Just point of clarification, when you use the word project, are you referring to the California WaterFix?
Yes, I am. The proposed project, California WaterFix.
I would refer you to Article 12C, where we're in condition of shortage. We can apportion available project water among contractors and basically, to paraphrase, our other contractors. So if the WaterFix was used to apportion, as part of our facilities, to apportion water among our contractors, that is within our ability to do so under the contract.
Does Article 12C use the defined term condition of shortage?
It refers to Article 12B, which does mention condition of shortage.
And Article 12B qualifies a condition of shortage under only certain circumstances, correct?
Yes.
So which of the circumstances in Article 12B would the proposed California WaterFix project fall within?
I think it's an incomplete hypothetical. You're stating the only reason we would be in a condition of shortage is because of the water fix? I don't think that's correct.
No, I'm not asking that at all. So let me just try to ask a very direct question about Article 12B. We just talked about how Article 12B uses the words condition of shortage, but qualifies it as only discussing condition of shortage under certain types of conditions. For example, errors in physical operations, drought, or other physical causes, and it goes on. I haven't asked my question, but I'm happy to.
Go ahead.
So my question is, does the proposed California WaterFix project fall within any of those categories of Article 12B?
The project does not.
Well, I'm going to object again on the vagueness of your question, because you're not differentiating between operations and physical structures.
Okay, let me try again with a further clarification. Would operations under the proposed California WaterFix project fall within any of the categories in Article 12B, and if so, which one?
Operations of the water fix. Again, you are assuming the operations are the cause of the condition of shortage.
I'm not assuming, I'm asking.
Well,
If any of these causes of the condition of shortage would be the California WaterFix.
Hold on, one at a time. Mr. Sahlberg.
Yes.
Mr. Sahlberg, let me try something differently. If under operation of the water fix, if operation under the water fix results in in errors of physical operations, or is an associate with a drought or other causes beyond the control of the contracting officer, is it your understanding that those conditions would meet the definition of shortage?
Let me say this. If the operation of the water fix by itself was the sole cause of a condition of shortage, I think we need to know, what do you mean by operations of the water fix? For example, the water fix may contain new outflow criteria, which is a legal obligation we would meet. So in operating the water fix, we have to meet that legal obligation, and that would be a cause of a condition of shortage if we're looking just at the water fix, and yes, one of those conditions would apply.
So thank you. I think we're getting somewhere, and I think you do now understand my question is what aspect of WaterFix could qualify? So are you saying that some aspects could qualify as one of these causes of a condition of shortage, correct?
That's not what I understand, but Mr. Sahlberg?
The water fix operation, the water fix is operated as a whole, and it includes, again, the legal obligations attached to it. So to try to tease it out, I don't think you can go there.
So are there, and this will be my last question before I move on, are there operations of the water fix that would not be one of the causes of the conditions of shortage defined in Article 12B?
Like I said, again, there's all the operations. I'm sorry, did you say not?
Correct.
I don't know how to answer that question. It's too vague.
Okay. So I want to refer back to the testimony you offered this morning when questioning was being asked by Ms. Ackroyd for San Luis Delta Mendota Water Authority. And I think I heard you testify that there are no contract provisions that give one contractor priority over another contractor. Is that correct?
Correct.
And are there any contract provisions that disallow or prevent such priority?
Not sure. I've never thought of it in that way.
But sitting here
Would have
today,
to-
you
sitting
can't
here
point to
today,
one,
I
correct?
don't know.
Okay. And are you aware of any legal requirement outside of the terms of this contract that would provide for such a priority?
No.
Are you familiar with a Court of Appeal decision commonly referred to as the Roby decision?
Yes, I am.
And are you familiar with the holding in that opinion regarding area of origin as it relates to CVP allocations?
Objection, holding, whether there was a holding in that case is a legal conclusion.
I'm sorry, whether there was a holding is a legal conclusion? Is that what you said?
Your characterization of Roby's discussion of area of origin vis-a-vis CVP water, whether that was a holding or not.
Understood.
Good, because I didn't. Go ahead and re-ask your question, Ms. Nichol.
Technical legal stuff.
Mr. Solberg, are you aware of any holding and it's his understanding of any holding regarding area of origin priority as it applies to CVP allocations in the Roby decision?
I am aware that it was discussed. I believe I'm not aware that it was a holding.
And can you describe for us your understanding of that discussion?
I believe the judge said, and in my opinion it's dicta, that he saw no reason why the area of origin statutes could not apply to CVP contract deliveries. I'm not making a direct quote, but that was the gist of it.
That's your understanding?
Yeah.
Yeah. And so is it, in your opinion, any provision of this contract inconsistent with that discussion in the Roby decision as you understand it?
There is no provision in this contract dealing with area of origin preference. That was requested during the contract negotiations, and the United States declined to add it to the contract.
I appreciate that, and I am asking a little bit different question. In your opinion, is there any provision of the existing contract that would be inconsistent with the discussion of area of origin in the Roby decision as you understand it?
If you do not know, you do not know.
I don't know.
This is my final question on this topic, and then I do have another line of questioning that's more specific to injury that we may want to pick up tomorrow if we really have a very hard stop. Okay. Mr. Solberg, would you agree that reclamation's allocations decisions under this contract are governed not only by this contract but also by state and federal law?
You'd have to talk to the operators about how allocation decisions are made.
I'm not asking about operations, but we have talked to them about that. I'm asking about what legal obligations apply as a matter of water rights to operations. And I believe that's within your area of expertise as a water rights officer.
Objection, you asked about allocations, and I believe Mr. Solberg is trying to say that allocations are an operations function.
But those allocations are governed, my question is, are those allocations governed by state and federal law in addition to this contract? As a matter of water rights?
To the best of your knowledge as a water rights expert, Mr. Solberg.
The state and federal obligations are taken into account in making allocation decisions by the Central Valley Projects Office.
I understand that they're taken into account, but are those allocation decisions governed by state and federal obligations, state and federal law?
I'm not clear about the phrase governed.
Obligated, bound?
They're, like I've said, they're taken into account.
That's your understanding?
Yeah.
Okay, thank you. That's all I have on that line of questioning. Should we resume tomorrow morning with the second line?
Yes, we will adjourn until tomorrow at 9 o'clock.
Thank you.